Even regards to item 34 of the supply list, I'm being for adjournment. This matter was actually listed today on the, and I mentioned it
Item?
earlier. But
32.
34,
What do you want?
I only an adjournment. Mr. Datta is not available.
Who?
Mr. S. Datta.
It is come up by order.
Yes, Lakshmi, it was indeed me who had mentioned this
Then
for listening today, but for some inconvenience, he had to leave for his hometown. The matter may come up next week also, he will be there.
Miss Enbora is there.
His envoy is not available. He isn't come.
Well, John is sign. This can't happen like this. When you mention the matter and it has come up, and then you cannot say that. The John is sign.
Lakshmi, it may come up next week if I may.
No, it will come up after 2 years, not to be listed. You have taken an advantage of mentioning the matter and then you are not there. I won't allow this. Sorry.
May I please? Lordship WPC 307-2026 listed at serial 30 of the supplementary list. I may be permitted to be adjourned for the day only.
Why?
I want to file an additional affidavit since additional material has come. There has been a modification of the order.
What is that order?
The order, they have extended that till 10th of March.
So
So I want to bring it on record.
there is no urgency.
I want to bring it on record, Lordship.
So you can give it to me. There is no
Right.
worry. I'll
Lordship.
take it up.
May I-
Because you have taken the permission. Now
Yes,
you can't take an
we have taken the
adjournment.
permission. So in
You
case we
have
can,
taken the permission from the chief.
we can.
And if you seek an adjournment today, means why should I should now point it out to the administrative order and bring it to the again notice that you are seeking an adjournment.
My prayer would be if it can be given to your.
So there is no urgency now. There is no urgency if it is extended till 10th of March.
No, there is certain this thing. I want to bring it on records. That's the only.
Okay, we'll see when the matter is taken up.
Yes. Much.
Please, my lord, prayer for listing of an election matter, my lord.
Why?
My lord, because there is a development in the case, my lord, post seniority matter, my lord, for challenging the post of Deputy General Inspector of Prisons, my lord. I was eligible for the post, but I was not given. We have challenged the seniority list, my lord. That is the case.
It's come up for admission.
Come up for admission. Matter of 25.
Okay, let's have it on 2nd of February.
My lord, that day I'm out of station. On that day I'm out of station. After that.
Okay, 7th of February.
I'm so afraid.
Maybe Lordship. I beg to mention for listing Lordship, in admission column Lordship, family pension method Lordship,
Huh?
family pension method Lordship.
Okay. 30
Alright.
January.
Listing.
Listing for what? For what?
That was suspension.
Huh?
That was listing.
You want the matter to be listed?
Yes.
Okay. Why? Why do you want the matter to be listed? Chalo, you find out and then again mention tomorrow. Chalo.
And this one matter for admission. Admission.
Why? Minimum scale. Okay. 9th of February. Chalo.
My pleasure, Lordship. So in this case, earlier I have approved this report and the petition was disposed of with the direction to make a representation against the request. It was the authority. Now they have come to the conclusion that I have never worked under FCS. But number of relevant records I have produced. my requisition, to show that he was under continuous service for.
Where is your appointment letter? Then how are you working?
Work.
The order or
I made a.
Mr. Purkasta, the order seems to be very reasonable. Passed by the FCI. Why don't you attempt? Why? What is this concept of regularization?
I made two full prayers. Either regularize or allow me to take part in the interview.
You filed an application earlier saying that kindly make me permanent or even appoint me as a contractual appointee. Isn't it your case?
My lord.
But there is no appointment letter. No letter. Now you want to bypass Article 14, 15, 16. Yes, absolutely.
At the same time, I made an alternative prayer.
That case.
That case, I know, my lord, absolutely.
Now let us go. I should send you to the division bench. Let me dismiss it right away. Heard Mr. A.K. Purkasta, the learned counsel appearing on behalf petitioner. Mr.
A.K. Singh.
So and so appears on behalf of the respondent numbers 2 to 8. Union, no union. None appears on behalf of the Union of India on call. The present petition has been filed by the petitioner challenging the order dated 3/9/2022, whereby the General Manager, bracket regions of the Food Corporation of India had rejected the representation of the petitioner on the ground that the recruitment appointment to the category of Group 3 and Group 4 Group 4 post in the FCI is done through open competitive examination with specific advertisement issued for such appointment as per the recruitment rules. Full stop. The case of the petitioner herein is that the petitioner have been engaged as what?
Engaged at grade 3.
Where is your engagement?
Engagement is not there, but they assigned you.
Have
work.
been engaged as a grade in the category 3 in the where? FSD? Sensua.
Yes, FSD censure.
Sensua. Sometime in the year 2013. And the petitioner thereupon have rendered continuous service their service. The petitioner had submitted representations before the respondent authorities for regularizing the services of the petitioner. However, as the representation submitted by the petitioner was not considered, the petitioner approached this court by filing a writ petition which was registered and numbered as WPC number 2309/2022. Full stop. The further facts of the case, as is apparent from the records, is that on 1/4/2022, the learned coordinate bench of the court had directed the General Manager Region FCI, Regional Office, to examine the petitioner's representation dated 2/8/2018 and take a decision on the same in accordance with law within a period of 2 months from the date of receipt of the certified copy of the order. Pursuant thereto, the respondent authorities in the FCI, more particularly the respondent number 9, have passed the order dated 3/9/2000, impugn order dated 3/9/2022, whereby the petitioner's representation was rejected on the ground that the petitioner is seeking appointment in the FCI for the category 3 or category 3-4 post. However, the recruitment oblique appointment to the category 3 oblique category 4 post in the FCI is done through open competitive examination with specific advertisements issued for such appointments as per the recruitment rules. It is also mentioned that a petitioner may apply for any of the advertised posts whenever such advertisement is issued, subject to meeting the eligibility criteria for the post. It is also categorically mentioned in the order dated 3/9/2022 that the petitioner was never employed by the corporation in any capacity whatsoever, and there has never been any employer/employee relationship. Full stop. This court have heard the learned counsel appearing on behalf of the parties and have also perused the materials on record. The records so produced, the enclosures so produced with the writ petition nowhere shows that the petitioner was issued any appointment letter by the FCI at any point of time. Be that as it may, it is pertinent to take note of that the FCI, that the respondent in the FCI, by the impugned order dated 3/9/2022, have categorically stated that they have that the recruitment oblique appointment to the category 3 and 4 post in the FCI is done through open competitive examination with specific advertisements. Full stop. Under such circumstances, any direction passed by this court to regularize the services of the petitioner would be in the teeth of the judgment of the Supreme Court of the Constitution Bench of the Supreme Court in the case of State of Karnataka versus Uma Devi, reported in 2004-6 4 SCC 1. Full stop. Additionally, this court, taking into account that nothing has been produced to the effect that the petitioner was issued any appointment letter by the respondent FCI, do not find the present case to be a fit case for entertaining. Accordingly, the writ petition stands dismissed.
That debate, what all debate was given to me, as and when advertisement
Full stop. Needless to mention that the dismissal of the writ petition, however, shall not prejudice the petitioner to apply for any post advertised by the FCI, subject to the petitioner meeting the eligibility criteria.
waiting,
What?
that-
Waiting?
Weightage.
Missed.
Obliged, my lord.
I have been continuous.
Sorry. Bad case. Yes, Mr. Padgiri. You don't have a case.
Resolution, no cut off that.
Obviously, the resolution takes a decision that look here, we are now thinking of that these employees will be given certain benefits of leave encashment and all. This is the resolution. So the resolution is of a particular date sometime in the year 2022. Thereupon, they have put it in effect immediately. 1 month thereafter, immediately, they see in view of the resolution adopted. So we now say that from 1/5/2022, these people will get it. So under such circumstances, what is your case? Unless you show me in any manner that a pension code would apply in respect to you. No, you don't have a case. On that day only, I wanted to dismiss. You said that, okay, don't dismiss today. Let it go after the vacation. Let us have a pure good bihu.
But if they
Bad
if
case.
After 22, my lord, I have received some amount, my lord.
Very good.
My lord, but till that he has not paid, my lord, that amount, my lord.
They will pay. They will pay. Whatever it is required, I'll mention it. You are entitled, if you are entitled, if you fall within, in terms with the resolution, if you are entitled, you will get it. But not to predate it to any other date. What do you say, Mr. Borpujari? Because as per the resolution which is there, where is that 315?
Page 87.
9687. So here they say, in view of the resolution of 29th of April 2022, they will be able to avail 1/5/2022. Now, where is your statement that you have not got thereafter? No, this is not your case at all. You wanted to make it predated. That is never your case.
In the writ petition, they have only challenged this annexure 12, page
I know
87.
that.
7 except that, my lord, that is the solitary prayer. Otherwise, my lord, if they are found entitled to the maximum limit of 300 days, the authorities will verify, my lord.
No, that's okay. He is challenging this. If he has not got the benefit, then you have a different cause of action. This is not the subject matter out here. So go and submit your representation and come back if you don't got it. Why? Okay. What do I dismiss? Withdraw with liberty to approve. Heard Mr. K. Padgiri, the learned counsel appearing on behalf of the petitioner. Mr. Arbor Pujari appears on behalf of the Finance Department of the Government of Assam. Mr. B.M. Bachcharji appears on behalf of the respondent number 1. The present petition has been filed by the petitioners challenging the order dated 9/6/2022, whereby the services of various work charge section assistant, work charge junior assistant, and work charge peon and chokidar, whose names have been mentioned in the said order dated 9/6/2022, have been held to be entitled to avail the leave encashment benefit with effect from 1/5/2022 and until further orders. Ustam. Mr. K.R. Padgiri, the learned counsel appearing on behalf of the petitioner, submits that taking into account that it was a decision taken only on 29/4/2022, that the leave encashment as well as the leave encashment benefit would be only provided to the various sections, to the work charge section assistant, work charge junior assistant, work charge peon and chokidar, who works in the Assam Police Housing Corporation. The petitioners herein would not like to further pursue the instant proceeding. However, he submits that in the circumstance the petitioners are not being paid in terms with the order dated 9/6/2022, the petitioners should be given the liberty to again approach this court. Taking into account the above, the instant writ petition stands closed on withdrawal. Full liberty given to the petitioner to represent before the respondent authorities to avail benefits in terms with the order dated 9/6/2022. It is further observed that in the circumstance the petitioners are not being provided the leave encashment benefits, the petitioners would be at liberty to approach this court. Leave encashment benefits in terms with the order dated 9/6/2022, the petitioner would be able. Yes, Mr. Orloskor, what is your case?
Petitioner's joint option form has not been accepted by the
Huh?
joint option form for higher pension, that the employee's pension scheme was not accepted by the respondent utilities on the ground that earlier they didn't have Aadhaar number was required, and later the time for filing the form was over. So therefore, I'm for your question. There is no dispute as to his eligibility.
Joint option form for higher wages under EPS.
No, I have to obtain instruction, my lord.
Okay, we issue notice.
Notice.
Issue notice making it returnable on how much?
3 weeks. my lord.
4 weeks, my lord.
On 9th of March 2026, no one appears for Union of India. Okay.
I appear for 1 and 2.
Now, Mr. S.K. Chakraborty accepts notice on behalf of the respondent number 1 to 2.
1 and 2, yes.
However, none has appeared on behalf of the Union of India on call, though their names are duly reflected in the cause list. So considering that there are, yes, you are a Union of India Council. Are you not a Union of India Council? Okay. Mr. C.K.S. Burwa accepts notice on behalf of the respondent number 3. Earlier matter also, I put your name. I dispose it. C.K.S. Burwa naam to kora diyo. Respondent number 1. Extra copies of the writ petition be served upon them during the course of the day. The grievance of the petitioner herein is that the petitioner have not been permitted to submit the joint option form for higher wages under the EPS 95, in spite of the fact that the petitioner otherwise is eligible and has otherwise eligible. First of the respondents herein are directed to bring on record their stand as to why the petitioner have not been why the petitioner joint option form has not been accepted by filing the affidavits on or before 26th of February 2026. Full stop. It is pending. It is observed that pending disposal of the the next state, it shall not be a bar on the part of the respondent authorities to accept the joint option form for higher wages under EPS 95, which the petitioner has submitted. Yes.
In case of the petitioner, working as a ACS officer, in law itself, because I think 30.
30.
Item 30.
Matlo. Yes, Mr. Bora.
My
What
lord,
is your instructions?
notice may be issued or
Understood. What is your instructions?
I have not received any instruction, my lord.
There were 10 posts
Yes, my lord. In the select
of
list,
radio. What is that? Radio?
radiotherapy.
Out of which 5 are for general, 1 is for SC, 1 is
Yes.
for ST, 1
Yes,
is STP plain, 2 for OBC and MOBC.
Yes, my lord.
Now, out of that, 33 persons were initially selected. Out of these 33 who have been selected, you have chosen only 8.
Yes.
Why not the petitioner? Is anybody selected as SC? That
SC.
is the only
Yes,
question.
my lord. I will obtain instruction, my lord.
We have it next week.
Yes, my lord.
We'll finish it off.
Yes, my lord.
Issue notice making it returnable on 2nd of February 2025, 26. Mr. D.P. Bora accepts notice on behalf of the respondent number 226, 224, 226.
2 to 6, my lord.
226, and Mr. D. Bora appear accepts notice on behalf of the respondent number 1. The grievance of the petitioner herein is that pursuant to an advertisement issued on, what is the date of the advertisement?
7/12,
Huh? What is the date?
7/12/2024.
7/12/2024, the petitioner participated in the said recruitment process as an SC candidate and was allocated a roll number bearing 12140017. The petitioner was selected on merit and was duly intimated. The petitioner, along with various others, were selected, were shortlisted on the basis of the marks and was duly intimated by the notice dated 24/6/2025. At this stage, it is pertinent to take note of that from a perusal of the advertisement, it is apparent that the post of radiotherapy technician, there were 10 posts of radiotherapy technicians which were advertised, which included 5 posts in the unreserved category and 1 post in the SC category. Full stop. The petitioner thereupon, it is the further case of the petitioner that on 12/10/2025, another notice was issued whereby the roll numbers of the provisionally selected candidates were mentioned. It is the further case of the petitioner that in the said provisional select list, the petitioner's name was not included, roll number was not included. However, only 8 out of 10 persons were provisionally selected. The grievance of the petitioner herein is that the post of the scheduled caste belonging to the scheduled caste has been kept vacant, and the petitioner in that regard had submitted informations, submitted request under the Right to Information Act 2005, but no information has been provided by the respondent number 5 and 6. It is under such circumstances the petitioner is before this court. The counsel appearing on behalf of the respondent number 2 to 6 shall apprise this court on the next date as to whether any scheduled caste candidate have been provisionally selected in terms with the notice dated 12/10/2025, and further as to what is the status of the petitioner's application, and what is the status as regards the petitioner's application in the recruitment process.
Obliged, my lord.
Yeah, what is this case?
Petitioner is willing to go for mediation.
Why is it come up from reference to mediation? Anybody wants to go for mediation?
We are ready. Our instruction is that.
We wouldn't have any objection.
You
we
want to
don't
go
have
for
any objection.
mediation?
Yes.
What is this mediation business? Let us see, what do you want?
Family pension matter. Even for family pension between the wife and the mother.
Who are you?
I am the widow of the.
First widow, second widow?
First, there was a earlier first wife, but she was divorced. Subsequently, he married me. But at the time of his death, I am the only legally married wife.
So then where is the question? Why you are going for mediation? You want to go for mediation? It's well and good. You go there. But don't you think this matter needs an urgent disposal?
Yes, in fact, by the last order, it failed. Unfortunately, my junior colleague was present. There is an order to implement.
There are 3 legal heirs certificates in the issue of family pension involved in the present petition. One submitted by the petitioner, that is by the second wife of the deceased, second by the mother of the deceased employee,
This is not valid.
and third by the first wife. First wife has also submitted.
First wife,
Yes.
wife
Yes,
has
Lord.
submitted a claim to the department. That has emerged during the pendency of this petition. Now, my lord, there are 3 legal certificates which are submitted to the authority. That is the issue.
But if there's a divorce, was there a divorce?
Yes, between the first wife and the late husband.
There was a
It's
divorce?
clear from the record.
You are
as well,
appealing for whom?
department. She's for the,
Yeah.
she's for the.
I don't have the file actually, Lordship. I'm not the engaged counsel actually. Mr.
You are
Kapoor,
nobody then.
Just,
Then why you are saying that you don't have objection to go to mediation?
that is it. I have been instructed by the engaged counsel.
Make an attempt to dispose it. The respondent number 5 has not filed any affidavit.
Who is response number 5?
He's
Huh?
the main.
The mother, forget it. Mother has no right. Mother has no business out there. As per the family pension code, does the mother get anything? No, she's, you see, the thing will be sent, paid to that particular person. That's the wife.
Yeah.
The wife has the first person. She gets the money and she becomes a trustee for the others. That's a different aspect of the matter. Why should this writ court involve yourself? Yeah. So that's the full bench judgment. Now the second wife, if it is the only wife, then there is nothing. What is the stand of yours?
Lordship,
Is
we
he
have
the
had,
only
yes,
wife
Lordship.
or any other wife?
Lordship here, Lordship, the divorce certificate is of from the Kaji, Lordship, whether this is a valid divorce certificate, Lordship, as now she has claimed for this, Lordship. Because we have categorically stated that we have no knowledge about the ongoing litigations and all these things, Lordship.
Where is the Kaji certificate
Page
divorce?
35 of my petition.
Huh?
Page 35 of my petition.
And page
This
40.
certificate was sent by the mother to the authority showing that there is a divorce between me and
That
the husband.
the divorce between so and so has been registered in the office of the Muslim Register of Iman as per Kula Talak as per Shariat.
And we made him a party, he has not appeared. We have served him dusty, he has not appeared.
Nilufar Begum.
No, Nilufer Begum means I am Nilufer Begum. But we have made even the Qazi a party.
You have a divorce.
No, no, this certificate is a fake certificate.
Okay.
Submitted by the mother to the authority, madam, in order to show. Whereas my marriage with the deceased was registered under the special marriage. It was not
Okay.
a Muslim marriage.
But there is no challenge to this divorce certificate. Your challenge is divorce. So if there is a challenge, can it by way of a mediation settle it up? My only question is this. Yes, after mediation, all these things may happen. That somebody may give up some rights or somebody may not give up some right. But can this divorce certificate be challenged? Be okay, the court will pass an order subsequently, but can it be on the basis of an agreement? Eh, You want to go to mediation, but mediation, that person has to be there, none the mother. Has the notice been issued?
They have served Wakalatnama. In fact, my learned friend who just appeared, his Wakalatnama is on record. His name is reflected in the cause list.
My name is reflected.
Then,
Record is not with me, this is with Mr. Tapada. He is not, he is out of station, Lord.
who is out of station?
A is Tapada. File is with him, Lord. Earlier I was not immediately, I didn't appear in this case, Lord.
In fact, they have filed their Wakalatnama in June of 23. They were in 26. They have not filed any affidavit with the council.
Oh my goodness, this is too delayed. Oh, anyways, Mr. Ganguly, your matters, we should delay it. I forgot that issue.
That's the
No. For your matters has to be delayed. That cannot have any urgency. I remember that case.
That is, ultimately, it was for the good.
So one thing means you need to settle with him,
With the mother.
mother.
Yes.
But
Not
the
mother.
problem is,
No, the mother has to be represented.
what about the second wife, first wife?
First wife that she has submitted a claim that has emerged only now.
So are you not challenging that?
The service, she is a divorced wife. How can the divorced wife be entitled?
Service book,
Service book is here, Lordship.
is it shown as divorced? Show me. But she's not a party here.
No, she is not a party.
Then you need to make her a party.
Exactly,
If
Lordship.
there is another claim filed by her, and this is already there on record in the order dated 3/11, then don't you think that you are required to make the first wife a party? Because later on it will be very difficult.
The only issue is here, admittedly, even as far as the service book, as far as our knowledge goes, because we are not in possession of the service book, that she is a divorced woman. Now, if she is a divorced woman,
Whatever may be, wouldn't it be passing an ex parte order? Huh?
but
Tomorrow, if you are on the other side, you will come out here and seek a review on that basis itself. It is already there. Mrs. Shira Chaltuna officially divorce order passed by the Honorable Guwahati High Court. Oh, Guwahati High Court has passed the divorce order.
Lordship,
there
that's.
was a decree from the lower court, then subsequently matter came here, then between those parties, then there was a decree from this one.
So now there is a divorce order somewhere. So there will be some order somewhere. But don't you think she has to be made a party?
Kind of that claim, perhaps she has to be. But there is an order of 311 in which this court has directed that the coordinate bench that the DC is actually made a party. I think that part of the order is not necessary because here that is
Not necessary.
junior colleague was not correctly applies the court.
Now you do one thing. How do you know that this particular woman, the earlier wife has applied?
Because they have said in their affidavit that
Lordship.
she has submitted a legal certificate.
In our
Official-
affidavit, we have submitted, Lordship. Legal certificate has been issued by the authority, Lordship. The affidavit filed on behalf
What
of
is your
respondent
name?
number 4, Lordship.
These certificates are issued just for the sake of it. Huh, madam?
Lordship.
This DC issues this certificate.
Yes,
without
Lordship.
motion. Anybody
Three-
goes and
for
applies,
three
you get a
persons,
certificate.
Lordship. Mother and two brothers, Lordship, then the first wife and daughters, two daughters, and the second wife, 3. That's why, Lordship, on last
No,
occasion.
you see it in the records.
Lordship.
There's a mention that the earlier wife had divorced
Yes, Lordship.
on the basis of Guwahati High Court order. You have a copy of that High Court order.
No, I don't have right now,
You
Lordship.
can find it out. And find out, and then we have it after 2 weeks. And then if there is any order to that effect, you will be able to find out, then we'll say that she has no business out there. So you become now the custodian in view of the full bench. If there and the divorce, can a divorce be granted by by the Qazi?
Yes,
A special
Lordship.
marriage act, it
Yes,
can't happen. So the divorce certificate will held it will be null and void.
Yes.
And the mother out here, she will have a claim against him. You will have a claim against him for him. That's as per the full bench per judgment, because he only gets it as a trustee. That's the full bench judgment. Have a look at it. Okay. This point, I don't think this is a case for sending it to mediation. If you want to go to mediation, well and good. Huh?
In the meantime, I'll try to place that.
Because it is already there. There is a Guwahati High Court order. It's already there on the records. So she produced the records on the next day. In the meantime, you just find it out. Because if there is, then you don't need to make them a party. Okay? Chalo. Heard Mr. A. Ganguly, the learned counsel, appearing on behalf of the petitioner, Ms. M. Bachcharjee, the learned senior government advocate, appears on behalf of the state, and Mr. So-and-so appears on behalf of the respondent number 5. Full stop. The issue involved in the instant writ petition pertains to who is entitled to the family pension. It is the case of the petitioner that the petitioner is the sole wife of late, what is his name? Late Imran Hussain Khandakar. Inasmuch as the first wife had divorced and the same have been duly recorded in the service book. This court have also perused the service book which was produced by Miss Amber Chetty. And from a perusal of the said service book, it is apparent that the first wife, namely Saira Begum, Saira Sultana, have been shown to have been divorced on the basis of an order passed by this court. Full stop. The petitioner herein also challenged the assertion made by the respondent number 5 that there is a divorce between the petitioner and late Imran Hussain Khandakar. The ground on which the petitioner have assailed his divorce certificate is that the Qazi cannot grant a divorce in respect to a marriage which had taken place as per the Special Marriage Act 1954. Full stop. Taking into account the matter in its entirety, it is the opinion of this court that this court have therefore heard the matter in its entirety. However, taking into account the submission made by the learned counsel appearing on behalf of the respondent number 5 that they need an additional opportunity, this court fixes this matter again on 6th of February 2026, 10th of February 2026, on which date an attempt shall be made to dispose of the writ petition. You get your books right.
Deeply.
You, in the meantime, get that thing. What is this?
My lord, non-release of family pension, my lord. I am the wife.
How many?
Private respondent is my stepson.
Huh?
The private respondent, respondent number 7,
Hmm.
he is my stepson and he is also claiming the family pension. And as
What is his age? Who is respondent number 7?
he has not appeared, the service of notice is complete, but he has not appeared. His age is 22 years. As of 20, so now he'll be 24.
Huh?
His age now will be 24.
Then
I am the sole wife, surviving wife.
you'll get it. Yes. Who are you? You are paying for whom?
BTC will be required in this case, Lord.
You are BTC,
No, I'm not BTC. I'm respondent number 1, Lord.
Chief Secretary.
Yes, sir.
Well, okay. The others? Who is paying for a pension?
Pension, I'm no, they depart BTC, Lordship.
Where is the pension? Department, the director of pension or party?
Director of pension not made party, Lordship, in this case.
What is this? Where is the AG a party? What type of case you have filed? From 2024, the matter has been pending. Who is not granting you the family pension? Who is going to grant you the family pension, Mr. Counsel? Who? Then you make the Chief Secretary unnecessary, Mr. C.K.S. Barua party. You have a good case, but don't spoil your case. What are you going to do? The counsel appearing on behalf of the petitioner submits that the petitioner would like to, family pension, does AG have any role? No.
Lordship, after the department send it to the AG of the verification document, then.
So the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file an application to implead the director of pension as well as the accountant general office as a party to the instant proceedings.
One more thing, DC may also be required to be filed, Lordship.
Why?
Because Tahsil here works under the office of Tahsildar, Lordship. So Tahsildar comes at a deputy commissioner, if I'm not mistaken.
What is that?
Working as senior assistant of the office of the Tahsildar Gosaigaon. So I think DC is required to be made party.
They made the Tahsildar party.
Circle officer is in mid party.
Tahsildar is a party. Okay, not necessary. I think he has to go for the director of pension here. So taking into account that 2 weeks' time has been granted to the petitioner to file the necessary application. After 2 weeks, এখন application file করবো date দিব নোৱাৰি। Yes, what is this?
Now work for continuous and uninterrupted service. And master role also in water resources department after he was released in because March 2017. He was not getting any pension or any pensionary benefit, hence the case was option. So I approached various authorities pertaining to it, but then I didn't got any.
Madam, you have a very bad case.
I have also filed affidavit, your lordship, that he is not.
You were
entitled.
released in 2017. You are approaching in 2024.
Meanwhile, I have approached the authorities. I have given a number of.
All understood, but you were removed from 4/3/2017. Now, how can I ask them to regularize or give you this? What is being given is given post facto. You want something which is prior to that. As of now, you are not in service.
14, there was a writ appeal and which honorable court had directed to regularize the.
But why didn't you approach then?
I did, your lordship.
Then what happened?
Then I, your lordship,
Where is it? You approached earlier.
6, 7, your lordship,
Huh?
5, 6, I made a number of representations, your lordship.
No, you approached, you should have approached this court. All this after you have been released. Retired on 30/4/2017. You cannot get it. After retirement, how can you get it? The benefits.
In fact, lordship, I have also stated in paragraph 6, 7, and 8 of my affidavit that he is not entitled. There are so many notifications, your lordship.
Finance department ready to regularize those who were appointed before Iman as a one-time. Okay, then.
As per Upendra's also, she is not entitled.
Lordship, may I take you to annexure number 10, your lordship, page number 37. Lordship, kindly, there is page number 37, your lordship, annexure number 10. It was dated 2nd February 2023. It was then when they rejected my case and when and in 2024 I approached on court. In 2023 they declared. They denied me the pensionary benefits and then in 2000.
Madam, you want to unscramble an egg.
That's from section 36 of
Huh?
section 36 of the Assam pension rules.
What is that?
Which stated that if I am doing a service continuously and uninterruptedly, then I should be given some pension benefit.
Madam, tell me one thing. Upendra's case
Yes.
says those persons who have worked for 10 years, you'll be giving them the minimum of the scale of pay. Okay. Then you took certain steps
Yes.
to give. Was it given post factor or prior to that? Where is Upendra's judgment? Where is Upendra's judgment? Madam,
Sir, I have.
your basic case is that only. You can't be regularized. I can't give you a post facto resolution, retrospectively. To immediately furnish its stand with regard to job security and retirement.
আৰু এইটো আপোনাৰ
What?
Give me 4 weeks time, Your Lordship, I'm satisfied. of the lordship.
What? 4 weeks time for what? For getting that judgment? I can get a printout now.
I'll file it with your under affidavit, Your Lordship.
Ah.
Send.
Or you want to go there? Because you see, this is not a matter which can be sent to mediation. Can it be sent?
No, Your Lordship.
It's impossible.
Yes.
You can't send this matter to mediation. Can the government out there say that, look here, we are going to give you? You want to go to mediation? People will make a joke of it. The
Yeah.
important matters which are there, which can be mediated, is a different aspect of the matter. You don't refer whatever may be. Yes, Mr. Barbujari, one matter, you see, Upendra's judgment says that those people who were working for 10 years prior to that judgment, that is 10/6/2017,
Yeah.
10 years prior to that, would be given the minimum scale of pay. Okay. Now, was it given prospector only?
No,
It was given from 10 years
10 years,
prior to that.
10 years ended from the date of
Now,
judgment.
here is a case. The petitioner was appointed in the year 1994. There's no quarrel with that proposition. Water Resource Department had taken a plea that we had earlier taken a decision, those appointed 1993, they would be given, they will be regularized and all. Now, here is a case where the petitioner have already retired in the year 2017, and he was given. But the fact that the petitioner at that point of time was having a 10 years prior to that. But the judgment of Upendra's came when? 8/6/2017.
8/6/2017. And it was more, my lord, circumscribed to the working, my lord.
Those who were working as
those
on
who were
that
working.
date.
That particular paragraph, my lord.
'42,
Yes, my lord.
isn't it?
That is my lord, paragraph 22.
Or 22.
It is, however, heartening to learn that the state government has agreed not to terminate the master roll workers and similarly placed employees working since last more than 10 years, not in sanction post, till their normal retirement, except on disciplinary ground or on ground of criminal offences. The state government has also agreed to enlist such employees in health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate this positive stand of the state government taken as welfare measures for the betterment and security of the employees in question. We accordingly direct the state government to implement the measures without further delay. Besides this, we, in the light of the decision of the Supreme Court in the state of so-and-so, Jagjit Singh, also direct the state government to pay minimum of the pay scale to master role workers, worksite workers, and similarly placed employees working since last more than 10 years, not in sanctioned post, with effect from 1/8/2017. 1/8/2017.
So therefore, it was given post facto.
Post facto.
So therefore, the petitioner having retired on 1/3/2017,
Yes.
petitioner can't get it.
Because had she been working, had the petitioner been working as on today, perhaps, my lord, the benefits could have been extended.
Or even if the petitioner was working as on 1/9/2017 also,
Yes,
then also the petitioner could have got 1 month. It is given post facto.
yes,
So you enhance the scale.
yes. Enhance the scale, and it was given with one retrospective effect, ante.
It was not given retrospective effect.
No, my lord, it will count from 10 years to count from, my lord, one.
No, no, no. The benefit is given to those persons 10 years prior to 1/8/2017.
Then that 10 years.
No,
has to be
it is
counted
given
back
to those persons.
Yes.
1/8/2017, 10 years.
10 years.
But the benefit will flow only post 1/8/2017. That
Absolutely.
is what is the
Yes, yes,
understanding.
yes. And pursuant to Upendra's, my lord, 2-3 notifications have also been issued by the finance department,
Hmm.
whereby the benefits have been extended, my lord.
Washington notification dated 8/3/2013 on perusal of where is that 8/3/2013? Where? You retired, where can you get a pension?
Which- The post, 2014, and the fellow master group workers, they got the benefits. And when I was in service itself in 2016.
No, those who were appointed prior to 1994, 1993 were being brought within the services of the state. That's a different aspect. You were appointed in 1994.
Yes, sir.
Now the problem is, how do this court do it in the year 2026? Tell me.
No, no, sir. I approached when I was in service and then I was given, I made a number.
Anyways, you don't want the dismissal right now.
Give me some time, your lordship. I try to satisfy her.
You are not going to satisfy. I tried myself to be satisfied with that. That is why I asked Mr. Arbor Pujari to read paragraph 22. You don't get the benefit of Upendas. You can't be given any retrospective regularization now. You have to be regularized, brought within the services of the state as on 1/4/2017. Then the pension will start from when? Tell me, you are asking something very impossible.
Lordship, the whole thing, basis that your lordship, I worked, I gave my whole life to this service, your lordship.
Fantastic. Everybody has, madam, the problem is not that. I have full sympathy, but the sympathy doesn't work.
70 years old, I have no family left. What will I do here? Give me some time so that I will be able to I'll try to satisfy the court or I will just transfer
It's why
it
the
to
court satisfaction is not there.
In fact, madam, the petitioner is claiming retirement benefits.
Is what I'm saying.
Hmm.
So therefore, what is required to be done in this case? Petitioner retired on 1/31/3/2017. Okay, now what should I have to do to give the benefit? The petitioner has to be regularized.
Absolutely.
Given a retrospective regularization with effect prior to 31/3/2017, meaning thereby you come within the ambit of the state government. One. Secondly, I have to further give you another 10 years benefit Otherwise, you are not going to get pension,
Yes.
which means I have to give you from 2007. Isn't it? So your regularization has to be dated back to 1/3/2007. In respect to a petitioner who has approached this court after 7 years post his retirement. So you want this clock to be not back for 10 years, almost 20 years. And if I give it to you, would there not be a plethora of litigations coming? That look here, there is one judge who is going to give this.
So what,
Tell me, tell me.
I gave my life, the service. for
Fantastic. You should have immediately approached this court also.
In 2023, they didn't decline, Your Lordship. I was making representation.
Where is the question of declining or not declining? How can, tell me one thing. Tomorrow, Mr. Borpujari, let us consider him to be the director of pension. And the director of pension says that, okay, this person, Abdul Wahib Ali, I'll give you. The moment he gives, the next question will come is the accountant general will catch hold of his neck and say, then look here, how can you give? See, has Rule 31 of the pension code. It requires, there are 3 requirements. First, he has to be services of the state. Second, he has to be also not only services of the state, his salary has to be made by the state. And the third, he has to be in respect to a post. Now the post which is there, which is a sanctioned post which is there, that cannot be, even the governor cannot say that, okay, give up these 3, number 3. 1 and 2, the governor can do something, explies discretion, but not 3. So how do I give you the benefit?
What can I see, Lordship? Because of
There cannot be anything. Sadness.
One another issue that may fall, I was about to spell it, my lord, Rule 31. Then second aspect that may fall out, my lord, is, my lord, if he sees to be, my lord, regularized prior, post, my lord, 1 to 2005, then she will come within the ambit of new pension
No,
scheme.
no, she will
Even,
come under, there again, no, it cannot be post, it will be post, so she will come under new pension rules. But be that with me, there might be a benefit of some leave encashment and all these things may come in. This is a different thing. But I have to back her, give retrospective back another 20 years.
yes.
So I do one thing, let me dismiss it. You go to the division bench. Division bench will also, I think, follow suit. And then the Supreme Court may help you out. 142.
done something for my senior, please, Your Lordship. Not today. Your
Counsel appearing on behalf of the petitioner seeks 2 weeks' time for filing a reply to the affidavit in opposition. List this matter when?
Lordship.
Okay, I won't be there on 23rd, 23rd of February.
All right.
Yes, Mr. B. Presta, who approaches with a grievance, the compassionate family has not been paid. Why compassionate family pension has not been paid?
Because his service was not regularized, Your Lordship. We received the instruction. The service was not regularized, Your Lordship.
But it is only to a regular employee one can get.
Yes.
Here it says it is to be given, CPS is not applicable to voluntary resignation or die in the cause of a death of the year, we want so and so, so and so, so and so. None of the family of the man applicable to employees living in a will be the definition of family. Okay, you are not a regular employee. What? Hello? Mr. Gogoi, can this matter be sent to mediation?
Since it's not regularized, there's no point of taking mediation.
No, by mediation, it just cannot happen. You do one thing, you have accept notice, why will you not bring on record?
I'll bring
your
this on
affidavit?
record, your lordship.
Then 1 week time.
Right.
Mr. R.R. Gogoi, the learned standing counsel appearing on behalf of the respondent submits that the question of the petitioner getting any benefit of the notification dated 14th of September 2017 does not arise, taking into account that the petitioner's husband,
Petitioner's husband,
petitioner's husband was not a
regular.
regular employee, as it be very much apparent from the writ petition itself, inasmuch as the petitioner's husband was a master role employee. Full stop. Be that as it may, it is the opinion of this court the said be brought on record by filing an affidavit. Full stop. List this matter again on 11th of February 2026. In the meantime, the affidavit be filed on or before 4th of February 2026.
Obliged.
1 week's time, we just bring on record.
Very well, lordship.
Hmm.
Kindly bring on order, we get 4 lines taking.
4/9 or 4/12.
Matter is pending before the division bench.
Division bench
Yes.
ruled against that matter. Honorable division bench ruled against that. And the matter was taken up to the Honorable Supreme Court. On 4/12/2025, the Honorable Supreme Court reversed the decision from Sarkar and restored the additional. For in view of the Honorable Supreme Court further, why not the Indian demand of the.
Where is that in Supreme Court?
Well, after the Honorable Apex Court order, the writ appeals were listed, and when the writ appeals were listed, it was on 6/1/2026. I have also given the order.
Just 1 minute. Wait, 1 minute.
পইচাটো যে সিহঁতে পালে সিহঁতে notice to demand notice to demand notice. See.
Now, what is your case here?
Yes, right. Petitioner is banned on 31/3/2015 from the.
31/3/2016. Both the petitioners,
From the.
same date. Died.
No, retired from.
Oh, retired, okay. I was therefore surprised.
Yes. Thereafter, the agency of they might have brought in division of trade rules 2017, which was given effect from 1/4/2016. And it also takes into consideration the person who decided the fiscal year, 31/3/2016, will be down to that category 31/3/2016. Now, by the authorities, without revising our last pay run, they simply revise our pension, revise our pension. That's why 1% came before the Honorable Court. And the learned single judge allowed the requisition by directing no. First you revise the last phrase now, then you revise the pension. Then accordingly the other is to petitioners were taken and similar order. How was I just in the first case? They defied the appeal before the Honorable Court. It was allowed by interfering with the learned single order. Thereafter the matter went to the Supreme Court.
But there are two appeals, one is 171 and 162, these are different.
Pending. And by the determine them, the Honorable Supreme Court order has come. When you place the Honorable Supreme Court order, cover, they say that we try to file a review, that's why time was granted. Otherwise, it is covered by the Supreme Court order. Now, in this, two cases, for your lordship, they have given a demand notice to refund the excess amount. Cannot be minor because Supreme Court has ruled in our favor by restoring the civil system. They are relying on dividend bench order, which has been set aside better.
These are, where is the impugn order in this? In 6098?
Demand notice.
6098, which is the impugn demand notice?
Page 74.
Yes, reimbursement of the revised here. So against your writ appeal is pending.
Yes.
Now, why a writ appeal is pending? Against that order by which the learned single judge had set aside. Now, therefore, their case is here that the matter went to the division bench. Division bench appeal is pending. Appeal is pending against where the single judges have passed the order and qua you in those two petitions. Their case is that only one of those persons went to the Supreme Court.
Because division bench in that case,
Understood. So one of the persons have gone to the Supreme Court. And therefore, the setting aside of the order by the Supreme Court of the division bench order is only qua him.
lordship is correct.
No, that is their contention. And therefore, in view of the fact that the division bench order is there, division bench has set aside.
In the first case, then the subsequent litigants came in.
Huh.
In the meantime.
Education stay order to get us.
So the-
এই অর্ডার গেছে appeal করেছো না? এইটো গেছে appeal করেছো না? হ্যাঁ?
Now they may be reversed and the change this order and next to.
So therefore, my problem of understanding is, while they rely upon another division bench order in that appeal, for your case, but they don't rely upon another order passed against that person, where the Supreme Court has upheld the single judge's order, holding inter alia that you are going to get the benefit because you are deemed to have retired.
4/12/25.
Or the stay order. So the stay is only for that petitioner. Wait, you are more confusing. You see the impugn order,
Lordship,
you take your seat. It's for the petition
Lordship. Here,
of
here in
that
this
person who went to the Supreme Court.
Muk-
What is his
Muk-
name? Mukut Das.
Lordship.
So therefore, you say that the interim order which was passed, because I think the division bench must have stayed the single judge's order.
Malad,
You see, these persons, both of them, take your seat. Both the petitioners are beneficiaries of
Mukut.
orders passed by the learned single judge,
Yes, Malad.
isn't it?
Yes.
Now, against that, you filed two appeals.
Yes, Malad.
Who are these two petitioners?
Those appeals are pending.
And those appeals, there's a stay being granted by the division bench.
Yes, Malad.
Okay.
Lordship.
Now, when the stay is being granted, you have therefore taken steps for recovery.
Recovery.
When you have taken steps for recovery, the petitioner comes up and says that in one of the cases where the division bench have set aside the single judge's order, the matter went to the Supreme Court and the Supreme Court have stayed recovery.
Lordship.
And therefore, the petitioner says that you should not therefore recover from us also.
Malad.
Now, by this impugn order dated 11/11/2024, what you say that that particular stay is only for the purpose of that Mukut Das,
Das.
which is however not applicable in respect to us
Right.
as against you.
You.
So therefore, you are liable to pay in view of the stay granted by the division bench.
Yes. Lordship.
That's the case.
That is the case.
Yes.
Here, Malad, in the writ petition, when they moved the writ petition, Honorable Court has granted stay. Against Malad, now Malad, the writ appeal is pending and the writ appeal order I have given on 6/1/26 when it was listed. Lordship has fixed the matter on 5/3/2026. And Malad, the APGCL is, Malad, we're in the process of filing a review petition before the Supreme Court, and that is what we have submitted. And accordingly, the writ appeals were listed on 5/3/2026. So, Malad, my respectful submission here today is, Lord, already they have got the benefit, whatever is, we are in the process of reimbursement that has been stayed. We are in the process of reimbursement. We issued notice for reimbursement. Otherwise, they got the benefit. Benefit, whatever is payable.
You are
they have-
trying to take steps for recovery.
we are trying to step
So
for
your
recovery.
recovery has been stayed.
That has been stayed. So no prejudice will be caused to them, my lord,
If
till-
the matter is adjourned.
if matter is adjourned.
That's
Lordship,
your case.
That is my case. Till the appeal is disposed of.
Huh?
Till the appeal is disposed of, my lord.
No. When did you file the appeal, review?
My lord, they are in the process, my lord, within day or two, my lord, they will file.
You have not filed the review?
No, they are in the process, my lord. I am told that within a day or two, they are filing it, my lord.
Okay, so you'll be filing the review.
Yes, my lord.
Sure. Hmm.
And considering that, my lord, these writ appeals were, my lord, adjourned on that day, till consideration of that. My lord, my humble prayer is that, my lord, that till consideration of the writ appeals, my lord, in respect of these petitioners. Otherwise also, my lord, they will not be prejudiced because their recovery has been stayed. So writ appeal 158 is in respect of the first petitioner, and writ appeal
Now-
162 is the second petitioner.
Heard Mr. J. Patwai, the learned counsel appearing on behalf of the petitioner. Mr. D. Nath, the learned standing counsel of the APDCL. Gusto. The issues in both the writ petition are similar. Taking into account that the respondent APDCL have initiated recovery proceedings against excess payment, and the same have been stayed by this court by interim orders. First, it is pertinent at this stage to take note of that both the petitioners in the two writ petitions retired on 31/3/2016. First, the case of the petitioners is that their scale, the pay scale should be revised in terms with the Assam Revised Pay Rules 2017, which was given effect from 1/3/2016. 1/4/2016. The APDCL authorities, however, refused to do so. This led to filing of writ petitions by the petitioners in the respective writ petitions by the petitioners, which were registered and numbered as WBC number 4384/2023 and 4381/2023. Both these writ petitions were allowed by the learned coordinate bench of this court by an order dated 29/9/2023, holding inter alia that the petitioners would be entitled in terms with the revision of pay rules of 2017 and thereby directing the respondent APDCL authorities to assess the entitlement of the petitioners and to pay the same within a period of 3 months from the date of the said judgment. The materials on record further reveal that though the APDCL authorities have preferred appeals against the order dated, against the judgment and order dated 29/9/2023, passed in WPC number 4384/2023 and WPC number 4381/2023, being writ appeals number WA 162/2025 and WA 158/2025 and 25. But in the meantime, the respondent APDCL authorities have already reassessed the petitioner's entitlements and paid the benefits in terms with the judgment or order dated 29/9/2023 in WPC number 4384/2023 and 4381/2023. Full stop. In the meantime, while the aforementioned proceedings were going on, another writ petition was filed by one Mukut Das, raising a similar issue, wherein the learned coordinate bench of this court, by an order dated 3/11/2022, by the judgment and order dated 3/11/2022 in WPC number 1607/2020, granted such benefit to the petitioner being Mukut Das. An appeal thereagainst was filed by the APDCL authorities before the learned division bench of this court. which was registered and numbered as, where is that number? 107 oblique 2022, 23. And the learned division bench of this court by the judgment and order dated
5/8/2024.
5/8/2024 allowed the writ appeal and set aside the judgment and order dated 3/11/2022 in WPC number 1607 oblique 2020. A special leave to appeal was filed before the Supreme Court by the said Mukut Kul Das, which was registered and numbered as Civil Appeal number 14559 oblique 2025, which was registered and numbered as Special Leave Petition C number 22297 oblique 2024. Pustak. Upon leave being granted, the same was re-registered as Civil Appeal number 14559 oblique 2025. The Supreme Court, by the judgment dated 4/12/2025, set aside the judgment of the learned division bench dated so-and-so in writ appeal number so-and-so and restored the judgment of the learned coordinate bench dated 3/11/2022 in WPC number 1607 oblique 2020. Pustak. Next. While the aforementioned proceedings were pending, taking advantage of the fact that the learned division bench of the court by the judgment and order dated so-and-so in writ appeal number so-and-so had set aside the judgment and order dated 3/11/2022 in WPC number 1607 oblique 2020, the respondents in the APDCL have issued notices to both the petitioner, respective notices to both the petitioners seeking recovery. Pustak. The learned division bench, the learned coordinate bench, by this order dated, by various orders dated, by respective orders dated 22/11/2024, in both the writ petitions have stayed such recovery proceedings. It is being submitted by Mr. D. Nath, the learned counsel appearing on behalf of the APDCL, that a review is being sought against the order dated 4/12/2025 passed in Civil Appeal number 14559 oblique 2025, and as such have therefore sought for an accommodation. Taking into account the above, lists this matter on 6th of March, these matters on 6th of March 2026. In the meantime, liberty given to the petitioner, to the parties, to mention the matter, apprising this court as regards the outcome of the review proceedings so filed by the APDCL authorities before the Supreme Court.
Okay.
Interim orders passed earlier shall continue till the disposal of the writ petitions.
My lord, this matter pertains to my lord regular pension. Initially, the petitioner was appointed, my lord, in the year 1982 as a Khalashi, my lord, and works as my lord Khalashi. And that works as Khalashi. And thereafter, his post was
In the year?
the year 1982, on 23/6/1980. I had my lord annex at page 27.
Thereafter, my lord, his post was upgraded, my lord, to works as plumber, my lord. And after, my lord, in the year 2005, his post was sanctioned, my lord, as phase 45, my lord. On 7th October 2005, my lord, I am directed to convey the sanction of Governor Assam for creation of 567 number of posts worked with effect from 22/7/2005 to 28/2006 under NCSSC zone in connection with the regulation of the service of 567, my lord.
Then?
His name is at page, my lord, 55, my lord. The lordship, my lord, content is 55. My lord, sorry, my lord, page 53, my lord. Sorry, page 53, at serial number 21 is page 53. Serial number 21 is Sadhan Uday, and your lordship may, my lord, mark the serial number 20, my lord, Bijan Hafilla, my lord, also.
What is this document?
This document is the, my lord, section of the 567 post, my lord. Thereafter, my lord, at annexure 11, my lord.
Now, what is annexure 10?
Is, my lord, for section of. This is the, my lord, list of along with the annexure 9, my lord. Court approval. And thereafter, at annexure 11, my lord, page 58, my lord, their post was, my lord, regular. Page 58, my lord. Here read, my lord. In person of the Gov order number certain such, but chief engineer Assam Hengrabadi, order number such and such dated 7/10/2005, 91 numbers of workers as per.
Where is the enclosure?
That enclosure is, my lord, annexure 10, my lord. At serial number 21 is, my lord, Sadhan Uday. And thereafter, my lord, at
Post the personnel to the respective. That means they are just made, supernumerary post. Okay, then,
page 61, my lord, and except 12, my lord.
so this happened on 26/10.
Yes.
Then,
Thereafter, my lord, at page 61, my lord. So order was, my lord, made by the commission secretary, my lord, finance department. All treasury officer with a copy of the annexure 1 mentioned above, they are requested not to allow drawal of the salary in respect of 321 number of worker and 456 number of.
so your regularization has been cancelled.
Cancel, my lord. That was not communicated to my, the petitioner till his retirement, my lord. And my lord, that serial number 20, my lord, Bijan Hafilla approached, my lord, this honorable court at page 54, my lord. Page 64, my lord, annexure 13, my lord. Please start from 65, my lord, by order dated 19/7/2023. That cancellation of regulation was, my lord, set aside, my lord. But who are the petitioner in that case?
Then,
At page 67, my lord. Second line, therefore, the subsequent order dated 10/2/2006 cancelling his order of regulation on the face of the record appears to be arbitrary and illegal.
and has any appeal been filed against this order?
And at serial number 10, my lord, one Haya Nanku is there, he also approached, my lord, this honorable court, and the same order was passed.
In that order, my lord may see, it was written qua the petitioner. my lord.
That's okay. I'm asking you.
After that, appeal was not filed.
So therefore, if the petitioner here is entitled to the same relief.
The serial number 10.
When did you retire?
Before 36/2020.
Then, Now tell me, now once you retire, you will now be entitled to what? How do you get regular pension, taking into account that you were regularized only on 10/5/2015, after 1/2/2005? You are regularized from 10/5/2005. You are regularized on that particular date, no? This is the document, 26/10/2005. You can regularize, but would you not come within the ambit of the new pension scheme? Taking into account the cut-off date of the new pension scheme is 10/2/2005. So then in that regard, if you were brought within the services, you will be getting it. But what about did they take any amount from you for deduction as per the NPS? Then
Because my lord, appointment is in the year 1980.
no, maybe 82 or whatever may be, the concurrence of the finance came on 22/8/2005. Then how do you get the old pension? My only question is that. You can't get the benefit of you may be getting the benefit of the new pension scheme.
My lord, my colleagues have also received the my lord old pension. Higher than Bijan Hakila, my lord.
You will be getting the same. I can give you only these things by setting aside the petition. Respondents are directed to give all consequential benefits. But you are not going to get the new old pension. Isn't it?
Regularization order also, my lord, executive engineer, my lord, cannot, my lord, regularize a person. He's relying on an order by executive engineer. My lord.
No. He's not relying on a executive engineer. He is relying on this particular document which is there. What is this document? This is given by the executive engineer.
Pension.
Where is the order of 7/10/2005?
My lord, annexure 9 case 45.
Where is your name?
Neither case serial number 21.
Of page,
50.
this is a part of that document,
Similar.
page 53. Then how did you retire in the year 2024? If your retirement date is 30/9/2023? Are you not Sadhan Haloi? Hosai, page 53. Date of retirement is 30/9/2023?
Yes, his date of birth, my lord, and after attaining the age of 60, my lord. He was retired.
You said that he retired in the year 2024.
Yes.
How? If his regularization order is, because Mr. Bhattacharya, if you see page 58, the executive engineer gives effect to the order dated 7/10. You see this, in pursuance to the government order dated 91, numbers of work charge employees under the executive director is brought under the so and so. This is based on 7/10. This is not based on 26/10. So therefore, he was very much there as on 7/10. The regularization is being made by the government.
And but the my lord may see the list which is enclosed, my lord, ending at page 57. That is signed by executive engineer, ma'am. But the accompanying order 710, that is signed by secretary, ma'am.
Understood?
There is no continuity in this document.
No, you see, therefore, the question is, let us read this file. Again, page 45. I am directed to convey the sanction of the Governor of Assam to creation of 567 numbers of posts. Work charge with effect from 22/7/2005 to 28 under the NHCC half-long as details below as per the format are enclosed in connection with regularizing the services of 560 workers who were engaged prior to and still working here without any interruption or break in service. Now he was working as plumber, isn't it? 12 posts. Of these 12 posts for work charge employees, here plumber, page 53, from 17 onwards. But only thing is, how did he retire in 2024? If he says so.
So, and I told the amount of return at page 72 of my additional.
Where?
At page 72, my lord, of additional. Page 72 and there is.
So the age was changed sometime after this 2005. Has the age been increased?
There is nothing on record to show that age was changed.
Yes, Mr. Barbadari, how do you take care of this thing? This judgment again seems to be something, it goes against my old pension, new pension judgment. Give him a copy of Hayan Apui judgment.
This order, my lord, at this order, Haya Namhui, at paragraph 4, at one point, this honorable court has held, my lord, that he is entitled. Then again, the honorable court goes on to say, my lord, that accordingly, the executive engineer PHE Umrangso division is directed to examine the service records of the petitioner. Upon examination, if he is found otherwise entitled to pension under the law, by accepting the qualified service as concluded herein above, the pension papers be processed and the claim of the petitioner be brought to its logical end.
Now, this is done on the basis of the office memorandum dated 6th of September 2003.
Yes.
6th of September 2000 says that it is reiterated that the OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits.
Yes.
The focus is on 20 years of continuous service. After rendering 20 years of service, if the government servant is supine or incapacitated or dead is not the moot question. Any confusion in this regard is against the spirit. It is therefore clarified the pensionary benefits as contemplated in the above motion. If to a government servant who died after rendering 20 years of continuous service, other terms and conditions for eligibility of pension shall remain as usual. Now, you see, once the regularization happens, on 7/10/2005, he was regularized. Now, if he is regularized on after 1/2/2005 is the date, cutoff date, then he is entitled to the new pension scheme. New pension scheme says about certain amounts to be collected from him.
Yes.
And certain amounts will be deposited by the government. Now, in this case, no amount was collected from him, but he was being paid the regular salary.
He was paid the regular salary, yes.
Now, coordinate bench have already held that the 10/2/2006 is wrong.
10/2/2006 is, my lord, has been set aside. So far as, my lord, that petitioner.
Maybe,
yes,
but
yes,
they
yes.
set aside.
Yes.
Here, On the ground given out there, it was taken as he was actually a plumber from 1999.
Yes.
But the fact remains that he was actually appointed in the year 1984, is the judgment of Justice Suman Shyam. But be that as it may, the court has set aside the 10/2/2006
And
for that petition. The
For that
petitioner
petition,
seems
yes.
to be on the same footing.
Appears to be on the same.
Same footing. Now, however, that judgment, however, says that whatever benefit he wants has to get, he will get it. Now, the fact remains that he cannot get the old pension scheme
Ye-
because he has been brought. That's
Yes.
my judgment.
Yes, yes, yes.
Now, the question is whether if it is not set aside by the division bench, I will only hold it that a person will being regularized means to being brought within the fold of the government.
Yes, Purnima Hore as on date has been not been interfered.
Into it.
Yes.
So therefore, so it will be brought within the services of the government as on 7/10/2005.
Yes,
But this is meets the cutoff after 7/10/2005.
yes, 1/2/2005.
1 to
yes,
2005.
my lord.
So
Yes,
this meets the cutoff.
yes,
So after such circumstances, the petitioner here will be benefited for the NPS.
NPS.
The NPS, if he has, you have not deducted,
Yes,
which you ought to have deducted,
Yes.
you have not deducted. But on the other hand, the other side have deducted. There is already an incumbent duty upon the state also to
Yes.
pay out regular its side.
yes,
So then how do you meet his benefits? Because you see, I can very well say that he will get the benefit of so and so. But this doesn't ends the problem for him to again come up and file another litigation.
yes.
How do you take care of that situation then? Mr. Counsel, do you get my point? Because
Now,
I can very well pass the same order. Ask him in the okay, change the dates and pass the order. There's no problem with that.
this,
But if you are entitled to the consequential benefits, you will be entitled as per the NPS. Now, the problem which will happen is the moment I pass that, they will come up and say that we have not collected from you, and so we are not going to pay from you. And more particularly when you have the PHE department on the other side.
now this order by the coordinate bench, my lord, Honorable Justice Syam, this is dated, my lord, 19th of July 2023. And my lord's order in Purnima Hore, that is 31/3/2023. So it is
That's
prior.
okay, but there, Justice Shyam's order does not deal with that.
Yes,
Kindly see
Yes.
paragraph number, last paragraph,
yes,
particularly paragraph, no, without a paragraph, page 67,
yes,
last to last one paragraph.
Yes.
For the reasons stated about this court is of the considered opinion that an impugn order dated so and so for the petitioner, thus cancelling the order of regulation is on the face of it arbitrary and the same is set aside. The petitioners are directed to give all consequential benefits to the petitioner pursuant to his regularization by the order dated in after adjusting the pecuniary benefits, if any, already paid to him.
perhaps, my lord, the answer may be found, my lord, here after adjusting. Now, my lord, he has retired. And till date, he has not got pension. If he has not got pension, if lordship directs the authorities to make a calculation, my lord, with regard to the, my lord, quantum of money that was supposed to be deducted, which had not been deducted, or supposed to be, my lord, contributed by the state, one has to
His pension will be less,
less.
taking into account there has been no deduction from him.
Yes, so let this exercise be carried out in terms of the new pension scheme. And the authority in the, my lord, the employer will coordinate with the finance department, more particularly the director of accounts and treasuries, who is the nodal officer for, my lord, new pension matters. So they director of accounts and treasuries.
You don't have a director of pension now.
No, finance department has a director of accounts and treasuries who is looking after the NPS matters, not regular pension. The regular pension, my lord, the 1969 rules are still being, my lord.
Director of pension.
Yes, yes, my lord, regulated
Director
and
of
governed by the
finance and accounts.
director of accounts and treasuries. Because if he comes under new pension scheme, my lord, a number has to be allotted to him.
Of accounts.
A token number will have to be allotted, and then, my lord, the calculations will have to be made.
So now he will be, have to be given a number.
Yes, that employee number, although he has retired, but notionally, my lord, these calculations have to be.
Personally, he has to be given a
Yes,
number.
yes.
By holding it to be okay.
Yes,
And thereupon to,
therefore, if those amount at that earlier point of time, if it had not been deducted from the petitioner's salary, and correspondingly, if the state has not contributed, I mean, from both sides, if no actions were taken, notionally, that has to be regularized now. That can be regularized, and at the end of the day, he will get the amount, my lord.
I think that is the best way to make a more clarity into this issue. Because tomorrow you may have a lot of difficulty again. I think that we
And-
direct the Director of Accounts and Treasury on.
And so far as, my lord, with all respect, my lord, this decision of Bijan Hapila, which lordship has just now seen coordinate bench decision, Justice Syams is, no, my lord, why I am submitting, my lord, some appeal might have been filed, my lord.
Which one?
My lord, against this Bijan Hapila, let me confirm it, my lord.
Which was the Hapila?
Bijan Hapila, I will have to confirm it with T. Nayak. Because he was the counsel who had, my lord, appeared in that decision, my lord, during hearing.
But here there is a concession by him.
The concession by him, my lord, whether. it's
Kindly
con-
see page 66.
No, yes, it is there, but whether.
Mr. Nayak, the learned counsel appears, submits, and the problem is that you don't have file an affidavit.
Yes, I think, my lord, we had written to the department.
Your department is not bothered. For them,
No, my lord,
he only twists the hands by not making payment.
department has in turn, lordship may peruse this, my lord, department has in turn, my lord, asked for all the particulars, my lord, from the PHC department, which is not forthcoming. That is my instruction.
PhD department is too busy embroiled in other litigations.
PHC, and in fact, the department has sought a communication to the general administration department also, because the data is with the employer. We are not the employer. So we
No,
will
it's
have
okay,
to.
but that is okay.
Yes.
But the only question is, here, that document having been set aside, 10/2/2006.
Set aside only with regard to Bijan Hapila.
No, that is a finance document. 10/2/2006 is a finance document.
This document, but it has been set aside for the petitioner in that case.
Maybe, but
Yes.
this is 10/2/2006 is, what does it say? Kindly see Annexure 12.
No, my lord, I am not disputing it, my lord.
However, continue to draw wages as charged and muster the if otherwise eligible. The salary in respect to the if already allowed to be drawn on the strength of the sanction issued by the concerned departments by letter in excess of the advance shall be recovered. They are requested to bring the notice to the EC department if found while passing any bills and so on. We do one thing. Let them file an affidavit as to whether in terms with the directions passed
Yes,
in the order dated 10/2/2006, have the PHC department taken any action? Squad the petitioner. Because the petitioner says that he received his salaries,
yes,
regular salaries after being regularized, because he was regularized in the regular scale of pay.
yes,
Master roll workers does not get it.
yes.
And this is done without taking into account, it says that there was an inadvertent error, so therefore we cancel everything.
Go to the category of grade 4. Grade 4, regular
Who?
petitioner.
Huh.
Yes.
So therefore he is getting the regular scale of pay.
Now,
Now therefore, if they are still, they continue to make the payment
Yes.
to him on a regular, meaning thereby this information was also negated, because this was not an information given to anybody.
yes.
Okay,
In
so
which-
where is that extract copy? So
Therefore,
copy of
minus
the
page
reference to
61,
so and so.
If lordship sees page 61, this is not the complete order.
Huh?
This is not the complete order.
Where?
61.
Kindly see page 63.
No,
This is
63.
the order.
No, this is my lordship will kindly see page 63 at the top. It is memo, copy with reference to so and so. This is not the order even, my lord. It is only the last part.
With
that-
copy
that
of
has been-
annexure 1 mentioned.
Yes, the recital of the order is not here.
Ah.
And he has put this order to challenge. He has
Hey.
not put that order on record.
We have to be, we are not taking a bench for. So therefore, we have to be lenient on that.
And so far as my.
You produced 10 to 2012. You are, it is your finance who have issued this.
Yes, yes,
You
yes.
produced this document. Okay,
And my lord,
you have a case, but this is to be.
only one submission, my lord, that page
Because
67.
you see, why I'm saying so, I also don't find it. You see, Justice Shyam's order, that particular, in that order of 10 to 2005, 10 to 2006, it is categorically mentioned that Kwa Hafela, that he was regularized only in 1999. He was only appointed in the year 1999 without taking into consideration that he was actually appointed in 1984. That is the reason why. But here it is only the copy to aspect is brought before this court, not the entire document. Okay, so let us get hold of that document in the entirety. He is going to produce. He is also going to file an affidavit as regards the credential, as regards whatever it is they stand on merits, and also as to whether the petitioners have been paid. Petitioner was paid the regular salaries pursuant to his regularization with effect till his date is retirement. Only problem, Mr. Counsel, is that how did you retire after? This has a very, it's a very difficult thing, although I would not rack up that issue now, taking into account you are a grade 4, no? Grade 4, I won't rack up that issue, but otherwise they will go for recovery and all, but that recovery in view of Rafiq Masih does not arise.
Recovery will not be permissible. It will only be a notional calculation, my lord.
Notional
And so far as page 67, my lord, for my satisfaction, my lord, the last but third paragraph,
Mm,
my lord, page 67,
mm,
my lord, for the reasons stated herein
mm.
above, this court is of the considered opinion that the impugn order dated so and so qua the petitioner.
No, you
That-
can, then the reason is at page 67, top portion, first paragraph. Therefore, the subsequent order dated here cancelling his order of regular on the face of it appears to be aware. The mere fact that on and from so and so petitioner was engaged a workshop plumber could not have been a valid ground to cancel his regulation. So therefore, the order of 10 to 2006 must have contained the reason for
Yes.
cancelling his regularization. And that also will be also a pertinent fact in the order of 10 to 2026 in 2006 insofar as the
Yes.
petitioner. So therefore, let us hold it.
My submission is, my lord, that 10 to 2006 order is still alive so far as this petitioner is concerned, subject to lordship scrutiny.
There's no, Mr. Borpuzari, I think I have understood that. I understand what is the meaning of the word qua. I heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. R. Borpuzari appears on behalf of the finance department of the government of Assam, and Ms. I. Botako appears on behalf of the PHE department, and Mr. So-and-so, S.K. Medi, appears on behalf of the accountant general. Full stop. You are water resource.
No, you're not, Dima Hafsa.
So-and-so appears for the Dimahasa. The petitioner herein has approached this court challenging the order dated 10 to 2006, by which the petitioner's regularization, which was granted on 7/10/2005 and given effect to on 26/10/2005, was set aside. The counsel appearing on behalf of the petitioner submits that similarly situated persons have been granted the benefit by the learned coordinate bench of this court. In the case of Bijoy Hafila versus the state of Assam and others, dated 19/7/2023. This court had perused the order dated 19/7/2023 in Bijon Hafila Supra. And from a perusal thereof, it is apparent that the learned coordinate bench have set aside the communication dated 10/2/2026, which have 2006, which have been impugned in the instant proceeding. Only Hua Bijon Hafila. Full stop. The petitioner's case is that the petitioner stands on the similar footing, and as such entitled to similar relief. This court have also perused the materials on record, and it is the opinion, and from a perusal of the materials on record, and more particularly the communication dated 10/2/2006, it appears that the same is an incomplete document. Full stop. More so when a perusal of the order passed in Bijoy Hapila Supra, it appears that there are indications in the order which was impugned. What the said Bijon Hafila as to why his regularization was cancelled. Full stop. The learned counsel appearing on behalf of the petitioner further had submitted that post his regularization with effect from 7/10/2005, the petitioner was brought within the fold of the state government services and therefore was entitled to and therefore was granted the regular scale of pay. The petitioner retired in the year retired on 30/6/2024, and thereupon could come to learn that the petitioner is not being given the benefit of the pension and other retirement benefits on the ground that the petitioner's regularization was cancelled on the basis of the order dated 10/2/2006. And it is under such circumstances the petitioner has therefore approached this court by filing the instant writ petition. It is the opinion of this court that for an effective adjudication, the order dated 10/2/2006, so far as the same relates to the petitioner, has to be brought on record. It is also the opinion of the court that the finance department would be in a position to bring the said aspect before this court. Another facet of the instant case would be as to whether the respondent in the PHE department have continued to pay the petitioner the regular scale of pay post his regularization dated 7/10/2005, in spite of specific directions given in the order dated 10/2/2006. This aspect would be relevant taking into account that if the respondent in the PHE department have continued to pay the regular scale of pay to the petitioner, it would have show that the respondent in the PHE department have not taken into account the order dated 10/2/2006 passed by the finance department. In that regard, this court therefore directs the PHE department to bring on record their stand by filing the affidavit. First up, list this matter again on unlucky 13. We have it on 12th of February 2026. In the meantime, both the finance department shall produce on record, the records of the order dated 10/2/2006 insofar as the same relates to the petitioner, as well as also copy of the communication dated 7/10/2025, which is the basis of the petitioner's claim. The PHE department is given the final opportunity to bring on record the stand by filing the affidavit on or before 10th of February 2026. It is observed that if the PHE department fails to file the affidavit, it would be presumed that the PHE department does not contest the case of the petitioner.
I will produce my lord 10/2/2006.
10/2/2005, because what he has done is like some snapshots and all. It's not so clear. So you have the 7/10/2005.
The 7/10/2005 is passed by them, my lord.
No. It's by the finance, whereby the government had regularized all 567 people.
7/10 to.
Therefore, it is 10/2 is cancelled.
10/2.
10/2 is being cancelled by the finance. Because
But
they by 10-2, they cancel 7-10.
It cancelled 710, but 710 was issued by the PHE. It is my lord annexer 9.
PHE is
Yes,
the
yes,
PHE.
PHE, yes.
But you have rejected it.
No, we have rejected, my lord. I will be in a position to produce, my lord, 10 to 2006. But so far as, my lord, 710, my lord.
710 is by PHE.
PHE, my lord, PHE is 45.
46, my lord, this issue as per concurrence of finance department by letter success.
So you'll have a copy.
But-
Fine. Because you see, asking the PHE, why
But
did I
will
put
try.
the last line?
Everything.
Because I'm making the preparation for the final judgment.
Yes, yes. my lord.
And knowing fully well that the PHE has some problems in filing affidavits.
I will. I'm so obliged.
And kindly, Mr. Bopija also give us a notion as to how we'll work out, if the petitioner's petition is allowed, how we will work out his pension as an NPS.
In fact, my lord, one matter is coming up before lordship, my lord, one in supplementary list, my lord, admission. There also the issue is same.
We'll
My
see
lord,
later.
to compassionate family pension, my lord, post facto. My lord, giving notional benefits by inculcating, my lord, NPS. I will produce it. I have the stuff. Right.
Yes,
Carrying of benefits, related to wives.
since the petitioner's second wife is seeking entitlement of the share in the pensionary benefit, being able on account of her husband's death by citing pressing need of upbringing her child, the said prayer can be considered only after notice. Who is paying for a private respondent here? You are the first respondent. You are the first wife. Hindu, Muslim. Then in that regard, you are a trustee.
My lord, why my lord learned friend filed my lord this, my lord writ petition, because my lord matter already settled in the Central Administrative Tribunal. Kindly see page 40.
Yes.
Page 40, my lord, paragraph 2. Paragraph 2. Accordingly, my lord, Postal Department, my lord, issue, my lord, speaking order, page 45. Page 45.
Now what do you want? No, what is that? You have already, no, Mr. Sharma, you have already accepted that. How can you say, you can quarrel with this order? And whenever you feel like, you go wherever you feel like. You were in CAT, come back here. What is this? Go to CAT. Or go to division bench. There is no business out there. And this is no mediation. After you have agreed, you are trying. I think this is a case, I think we should be dismissed with cost. No cost. Yeah, this is an abuse of the process of the court. You pay him Mr. Chauhan's fees, whatever he has taken, you pay him the fees. That is the cost. And pay Mr. A. Gayan her also fees, because filing unnecessary type of petitions out here. No. Huh? Who? Then you pay. Mr. R. Soma pay from your own pocket for indulging into such frivolous litigations. No, I'll impose the cost upon you. If he waives, Mr. Sohan, if you waive your fees from him, you don't want to take it from him, it's okay. But otherwise, I'm imposing the cost. Mr. Ash, you demand him and he will pay. And then both of you go to the suit.
My lord, same council, that is a strange,
Huh?
my lord, same council.
Understood. He has duly accepted the same and 1/3, and this is what is being given out there.
to the minor.
And you are the second
Minor
wife.
is the second wife.
You are the second wife.
Yes.
Yeah.
That's right, Your Lordship. But then you are also-
Where is the division bench order, the full bench order? Let me put a death nail to this entire litigation with death judgment. Cost upon you. R. Sharma, advocate.
160/2018, my lord. Decided on 22/12/2023.
That's by Justice Shaya and all, the full bench.
Bench order.
Judgment will light you. Let me dismiss it with cost upon Mr. R. Sharma. We put it at 50,000, your fees, Mr. Sohan.
My lord, I will leave to your lordship, my lord.
50,000 for he pay for, and Miss A guy on another 15,000, 65,000. You pay from your pocket for Indian indulging in this.
That's it. That will be a-
No, why? You see, after Mr. Sharma, you have to understand. Geez, after all, this lady is a pensioner. She is getting 1/3 on account of your agreement. And you have duly agreed to this. So under such circumstances, why on earth you are filing again another writ petition after making the submission? Or you may say, your client may very well say that, look here, R. Sharma was never instructed to say that he is satisfied with 1/3. Then go to CAT and get it reversed there.
Ticket was not here, and I on my own. Let it feel fair, that 1/3 should be fair enough. That is why I agreed, Your Lordship. And that's better, Your Lordship, I am instructed because I am not satisfied with 1/3. Because I have a child to take care of. And take care of his education also. Therefore, I want this 50%.
So therefore, what are you going to, what should you do? You should go to CAT, engage another lawyer. Let me give you a suggestion. You go to CAT, engage another lawyer and say that Mr. R. Sharma was never instructed. No, listen. Or you may go and file an IA before CAT and say that, you see, I said this 1/3 from my own without my instructions. And therefore, kindly take up this and let it be considered as per law. But you have to go to CAT for that. But how can this court say anything? Tell me. I can only pass an order dismissing. But I can otherwise pass an order of withdrawal with liberty to approach the CAT. That's another thing. Then I have to say that Mr. R. Sharma said without instructions, and as such, the petitioner would like. Would you like that thing?
An observation.
Because of you, this client, that is why I'm saying, you are approaching this court. The client should engage somebody else. Don't you think that? You have a junior? No junior. Where is it? Get her. Let her say. You don't say anything. You sit down. I'll take her submission. That Mr. R. Sharma said without instructions about this 1/3. And therefore, I say that liberty should be given to therefore the petitioner that she approaches the CAT for this. You like that? Because this is what has happened. Don't you think so?
That's the right question.
That's the word. But you can't challenge it here. What do you say? I pass that type of order? We also provide that in the event of any such person who are entitled to the benefit of family pension in terms of surrender, including the second or the further wives in any case where the parties are governed by Mohammedan law, are not appropriately maintained by the eldest of the surviving widow or the wife to whom the pension would be paid, the remedy thereof would be to make a claim for maintenance in the appropriate forum under the law. This is the law of the full bench.
Paragraph 22 says that there is no bar, okay. The second one also.
It's all right, Your Worship, that was-
No, you become a trustee. He becomes a trustee of that. So therefore, you will be entitled to as per it is if you have more further claim to that. But that also you have to understand that that claim is subject to many other aspects. But here, because of your fault, this has happened. So for me to therefore say anything else would be, I can't say anything because it is already on record. I cannot sit over you, but I can give you the liberty if you want to go to CAT. But otherwise, the only thing is to dismiss it. There's nothing wrong with that order. Or I can say one thing, taking into account that judgment, that 1/3 it is okay, what is being given. But if you have more maintenance dues out there, you can make it a claim before the appropriate forum
Because my lord,
without being influenced, and the authority shall, or court or authority shall consider it without being influenced by the stand. Because at that, I can very well say that 1/3 was at that point of time seemed to be appropriate. But taking into account now the additional expenses which happened in the meantime of the kid and all, so he may ask for more, and that will be subject to what the authorities may decide.
already 10 years passed, my lord, person died.
Who died?
On the 14/5/2015.
Who died?
Husband died.
Husband died, but you see the expenses have increased. The child may have many other things. So he said that was without instructions. He said, but anyways, let us take it with instructions. He said. He said 1/3, but 1/3 may not be the optimum at all points of the time. There might be more expenses out there. So he may therefore given the liberty to approach the appropriate forum as per the judgment of the full bench and ask for more maintenance if it is required. I think that is a fair thing. You are agreeable is not the question, because of your agreeable the problem has ensued. No agreeable. Let me come back at 2. I'll pass that order. क्या rules कौन सा? Get. Get. Administrative tribunal. There's a rule of the cat, na?
Yes.
No. Cat was cat was. This is Department of Post, na?
Yes,
My
ma'am.
lord. My lord, in this case, other facts are like this, my lord. If you lordship see page number 20, my lord, this petitioner filed, my lord, there's one succession case in the Jorhat court, my lord. And my lord, notice was not served. The expertise order was passed, which is, my lord, annexure D page 20. And before that, my lord, one civil suit was also filed in the Jorhat court, my lord. A notice was not served, my lord, to my client, my lord. Subsequently, that suit was withdrawn, my lord. It is not stated in the writ petition. I have the copy of the order.
Department of Post, is it under the cat? Does the cat have jurisdiction?
Yes, my lord. Cat has jurisdiction, my lord.
Huh?
Yes, ma'am.
Where is it?
Order bracket,
Cat, this departmental post will be under which jurisdiction?
CCS. CCS or C. Central Civil Service rule, my lord. I think all central government employee, including railway post, my lord, applicable.
Jurisdiction is section 14 of Central Administrative Tribunal, my lord.
Hmm?
Jurisdiction of the cat is, my lord. Jurisdiction of the cat, my lord, that is section 14, my lord,
Of the?
of the Central Administrative Tribunal Act.
No, understood, but Central Administrative Tribunal Act.
That is Central Administrative Tribunal Act 1985. Section 14.
No, that's okay, but it is in respect to, if we see the Central Administrative Tribunal Procedure Rules 1987, classification of cases department wise. Now, whether the postal department falls within the ambit of CAT,
I think so.
the department wise is found out there in Annexus Appendix 6. Ministry of Communication is not postal department.
Postal Department is under. Ministry of Communication, my lord. Postal is Ministry of Communication.
Is under CAT. Ministry of Communication. So, if it is under the Ministry of Communication, Department of Post, this order has to be challenged in CAT only,
Yes, my lord.
isn't it? And because of that, I can't exercise jurisdiction. I'll dismiss it on that ground. You go there.
Yes, my lord.
Heard Mr. Ashrama, the learned counsel, appearing on behalf of the petitioner. Miss A. Gayan appears on behalf of the respondent numbers 1 to 5, and Mr. S. Sohan appears on behalf of the respondent number 6. The petitioner herein have assailed the order dated 3/9/2024, passed by the respondent numbers 4, whereby the family pension and retirement benefits of late Atikus Zaman was apportioned amongst the petitioner and the respondent number 6 in the ratio of 1:2 was apportioned, thereby entitling the petitioner to 1/3 of the pensionary retirement benefits and 2/3 to the respondent number 6. Pustak. This court duly takes note of that the jurisdiction in respect to in respect to the dispute falls within the ambit of the Central Administrative Tribunal, Guwahati Bench. And it is of vital importance to also note that the respondent number 6 had initially approached the Central Administrative Tribunal, Guwahati Bench claiming family pension, gratuity, leave encashment, benefit of GIS and other retirement benefits, wherein the petitioner duly participated. The said proceedings was registered and numbered as original application number 040/00305/2019. The learned Central Administrative Tribunal Guwahati Bench, by an order dated 22/4/2024, directed the respondent number 4 herein to reconsider the case of both the parties, taking into account the service book and disburse the family pension as well as the retirement benefits to the respondent number 6 in the light of the service rules of the Postal Department, and communicate their decision by way of the reasoned and speaking order within a period of 3 months from the date of receipt of the order dated 22/4/2024. This court further takes note of that in the said order, the respondent, the petitioner, was duly represented and his counsel had submitted that the petitioner is ready to accept 1/3 of the retirement benefits as per the rules. Pustak. Pursuant to the said order dated 22/4/2024 passed by the learned Central Administrative Tribunal, the impugned order was passed on 3/9/2024, whereby 2/3 of the pensionary benefits have been accorded to the respondent number 6 and 1/3 to the petitioner. Full stop. At this stage, this court finds it relevant to take note of the judgment of the Constitution Bench in the case of L. Chandrakumar versus Union of India and others, reported in 1997, 3 SCC 261, wherein the Supreme Court at paragraph number 90 categorically held wherein at paragraph number 93, the Constitution Bench of the Supreme Court categorically held that the tribunals would continue to act as the only court of the first instance in respect of areas of law for which they have been constituted. Also, it was clarified that it would not be opened for litigants to directly approach the High Court even in cases where they question the virus of statutory legislation, bracket, except as mentioned where legislations which create the particular tribunal is challenged, bracket, close, by overlooking the jurisdiction of the tribunal concerned. Paragraph number 93 of the said judgment being relevant is reproduced hereunder. Also, it is relevant at this stage to take note of section
In my lord.
14 of the Central Administrative Tribunal of the Administrative Tribunal Act, huh?
Yes, my lord. Central Administrative Tribunal Act.
Of the
1985.
Administrative Tribunals Act 1985. Whereby jurisdiction, power, and authority of the Central Administrative Tribunal have been stipulated. This court further takes note of Rule 154 of the Central Administrative Tribunal Rules of Practice 1993, which stipulates the scrutiny of the scrutiny which stipulates that the scrutiny branch of the registry shall at the time of scrutiny make classification of the cases department-wise, subject-wise, and cases which are to be heard by the single bench. The department-wise classification have also been mentioned in Appendix Roman 6 of the said Central Administrative Tribunal Rules of Practice 1993. From a perusal of the appendix Roman 6, it is seen that the Ministry of Communication comes within the fold of the department-wise classification of cases. Pustam. The Department of Post falls within the ambit of the Ministry of Communications. Under such circumstances, it is therefore the opinion of this court that the petitioner, without approaching the Central Administrative Tribunal Guwahati, cannot directly approach this court, assailing the impugn order dated 3/9/2024. In view of the law laid down by the Supreme Court in the case of L. Chandrakumar Supra, and more particularly to the paragraph 93 as quoted herein above. Next, in that view of the matter, this court is not inclined to entertain the instant writ petition. In that, accordingly, the writ petition stands dismissed. The interim orders, if any, passed, stands vacated. Next. This court, however, observes before parting that as this court is not entertaining the instant writ petition, it shall not be a bar for the petitioner to approach the Central Administrative Tribunal Guwahati bench. If the petitioner is aggrieved by the order dated 3/9/2024.
Regarding the cost escalation aspect.
What?
To approach the authorities, if I may approach the authorities for enhancement of the.
Go there, cat. Because if I touch here, everywhere I'll have to touch. I have to be careful.
I think almost done.
This is the second time the matter has been called. However, the counsel for the petitioner is not present. Pustak. This court have duly taken note of the administrative order passed by the Honorable Chief Justice, wherein on the basis of claiming urgency, the Honorable Chief Justice has permitted the petitioner to move the instant writ petition in the principal seat of the Guwahati High Court. Taking into account that the counsel appearing on behalf of the petitioner is not represented in spite of the name duly being reflected in the cause list and the writ petition being taken up, called twice, first in the first half, first prior to recess and secondly post recess. It appears that the petitioner does not, the act on the part of the counsel does not inspire the confidence of this court that the petitioner has urgency. List the matter after 2 weeks. List the matter again on 13th of February 2026. The registry shall show registry. 13th February.
Lordship, in the last hearing, Lordship, your Lordship has put me some questions and has prepared them accordingly, my lords. But before, my lords, there were two issues in this regard. The later issue is that there were some statutory dues which were, so these are the, my lords, the outsourced workers who work with the contractor. And then, my lords, they have been working since the last 10-15 years. The contractors have changed, but they have stayed at the site of APGCL in various sites of APGCL. My lords, the second issue, with regards to the fact that the statutory dues were not paid, well, to this people, to this workers. With regards to that, madam, respondent number 9 has appeared, entered appearance, madam. In our affidavit in reply, madam, we have to the respondent number 1, we have already stated that the dues have not been received. Well, they have said that their dues been received. Madam, in their affidavit in opposition, they have given many annexures, but none of the annexures, my lords, the categorical. I have asked my clients, they have said that they have not received any dues. Well, in their affidavit in opposition also, well, they have not annexed any document to show that the statutory dues that they have paid.
The council, your dispute is qua the respond number 8 and 9. 9 and 10. You want to hold the APGCL responsible. Isn't the APGCL enter into a contract with respond number 9 and 10?
Yes, well, they entered it.
On the basis of that contract, they say that they have paid.
They have paid.
Respond number 9 categorically says in the affidavit, respond number 8, the APGCL, who are the respond numbers 1, 2, and 3 have filed an affidavit in opposition, wherein they say that all the dues as regards the respondent number 9 have been duly cleared. Respond number 9 is cleared. The APGCL further says that after 2024, 36/2024, respondent number 9 is nowhere in the picture. Another contractor, that is the respondent number 10, is in the picture. And they have paid whatever is due to the respondent number 10 by the APGCL.
Here, with regards to respondent number 9, so the
Respondent number 9 is Vanguard.
Vanguard. So, yes.
Now, respondent number 9 says they have paid it to you. You say you have not received. Isn't it your dispute qua the respondent number 9 and 10?
If in any way, if tomorrow the dispute remains that the ultimately the payment which was due upon the respondent number 9 has not been paid to us, well, then it will fall back upon 21(4) that if respondent number 9 does not pay to us, then it will be the principal employer which will be liable.
How?
Well, 21(4) of the Contractual Labor Act says that. CLCC.
Contractual Labor Act, the principal will be liable.
Yes,
But they say that they have paid.
Well, then there's an inner dispute, but ultimately I have not.
So
been paid.
therefore, how does this court, a writ court, resolve the dispute? You are entitled. The fact that you are entitled is not in the doubt. The fact that you are entitled to certain dues as per your contract entered into with the respondent number 9 is not in doubt. But the fact that whether they have paid or not is a question which needs to be decided by a forum where evidence can be led. They categorically say that, look here, we have made the payment. You say that we have not received. How can this court decide?
Well, that is the second issue.
That is the prime issue.
No, the prime issue is another matter. That is the matter with regards to any assets. The prime issue here is this matter. That is with regards to respondent number 10. Respondent number 10, what happens, Millards? So when they enter into the work contract with APGCL, Millards, so basically they had actually brought in Millards. So Millards, I had done a research on this. The question that is put, this is a APGCL tender document, Millards. If I can please speak to the court, Millards.
Mr. D.S. Bhattacharjee, why you are not there when the matter has been called up twice?
Lordship, I want to get it photostated.
What?
For the photostat of the.
So photostat, does it take it? I had it in the first half. You were not present. Second half, again I called up at 2 o'clock. You were not there. So under such circumstances, I posted it on February 13, drawing to the attention of the Chief Justice that what you have taken an order on the basis of an urgency and you are not there twice when the matter is called. This is not a thing which inspires the confidence of the court. It's very, it doesn't look nice.
Right.
So basically, this is the tender document on the basis of which NESS, the respondent number 10, entered into an agreement, into a work order, which was annexed by the respondent number 1. So, in this case, we have said that when NESS has actually tried to enter into a work agreement, just asks us to sign a contract. That is an employment contract. It is we have attached in our page number 80 to 81 of our instant repetition. They say there are some unconstitutional clause and there are also clauses which also violates their tender conditions in the tender.
This is name of the work. This is by APGCL.
Yes, Miller. And on the basis of which, the NESS has entered into the work order.
Then?
Yes, Miller. So basically, the argument that I'm trying to build is this, that when NESS enters into an employment, entered into the work contract, hereafter what happens, that they had approached us saying that we will continue your service provided you sign this agreement, employment agreement. Because that employment agreement is violative of the fundamental right. And says, on the last occasion, has put me a pertinent question that with regards to the agreement between me and the employment, where the respondent number 1 has categorically denied that this is the internal matter and we are nowhere concerned about it. Well, it's my humble submission before this honorable court is this. When there is a violation of fundamental right, because in the employment agreement, because all the statutory dues and everything we have put it before the conciliation officer, and all these things have never been resolved, and the reason which we have process honorable court. In this employment agreement, which is now forwarded by NESS to us, they say that you cannot form any association. First thing being that. Second thing they say that if you have to start your agreement, you have to submit a 1 month salary before with us. You have to deposit a 1 month salary wage for our administrative expenses. Third thing they say that in the
But is this contract which is entered into with the respondent number 10?
Yes, Manoj.
Which is imposing. Is it based upon what the APGCL is ordering them?
Because general terms and conditions, the general terms and conditions of the court, if you see the standard document, you will see that they have a deep and pervasive control over the working of respondent number 10.
Maybe, but is it your allegation out there that it is because of APGCL these terms are being inserted?
It is my allegation that because we have alleged them, despite that they have not taken any action, because of this oversight, it is in effect, that they have approved these conditions,
Who?
Because action and inaction, APGCL, because both action and inaction can lead to an approval of an employment agreement. It can be either can be a positive action or it can be a negative action. They have just because given an inaction, despite you have said that there is an agreement which is unconstitutional, they categorically say before in the affidavit that we are nowhere to see what is the internal matter between the contractor and the workers.
So you mean to argue, therefore, that when APGCL engages a contractor, the terms which the contractor imposes upon its workmen cannot be onerous terms, and it is a duty upon the state authority, that is the APGCL, to ensure that.
Yes, to ensure that any term work order.
Now let us see this work order, the supply order. How do they tell? Shall have been issued a personal year, barracks so and so, the successful tenderer shall submit a year. There will be some terms pertaining to contractor shall make an ESI has to make ESI, the contractor or his nominee shall ensure presence of short notice and no other area shall be liable to pay compensatory in case of accident or involved. Statutory obligation to taxes fee and refund in costs related to salary, PF, emoluments. Where is your allegation to that effect?
In our repetition,
Where?
the repetition melody in page number, in annexes 6 melodies. And we have further replied. that
Now,
we-
where is your allegation in the petition?
Look in 9, 9. Okay, paragraph 9 of our paragraph 8 melodies and then paragraph 9 of our instant repetition melodies.
Are you a workman?
Yes.
Do you fall within the ambit of workman?
Yes, sir.
Then wouldn't this be an industrial dispute?
Melodies, even if let's say, therefore my argue is this melodies, that since there is a violative of fundamental right.
So
they-
the violative of fundamental real right may be a case of an unfair labor practice.
Yes, melodies.
But how can this court take it up? Because these are questions which will require evidence.
Melodies, this will not. Exactly, melodies, that's my submission. Melodies, because here we have brought forward before this honorable court of an employment agreement, melodies, which is violative of the, because melodies, in this, there's a judgment of the Supreme Court also which have brought melodies. Because of there being an alternative remedy melodies, if there are 3 triad cases which has been laid down with the Supreme Court, melodies, if I may produce the judgment melodies.
Tell me. Let me tell you what is the judgment.
Urban Slan, Urban Slan versus Indian oil melodies.
You are referring to the last paragraph, the last 3,
Last
which are the exceptions being created to a writ,
Yes, melodies, the last paragraph.
failure of natural justice,
Yes,
violation of Article 14. Isn't it?
yes, melodies.
Is it?
Yes, melodies.
I'm not on that.
Yes, melodies.
But the question is, if it is an unfair labor practice, you are a workman. If you come within the ambit of a workman, as per the Industrial Disputes Act, they are asking you to sign an onerous agreement by NES, which is the response number 10. You have gone to the conciliation proceedings.
No, not with regards to this.
Where?
Well, because when we filed this instant writ petition was before when NESS came into Millards, into picture Millards. Because we filed on the day before that, because Millards, in the conciliation proceedings Millards. So what happened Millards, we have put forward all our grievances. The conciliation officers say that their grievances they categorically say in page number 78.
8? 17?
8.
Yes.
So this was pending statutory dues memo. So first of all, with regard to statutory dues, Millards, conciliation officers say that Millards, they should not be released, Millards. Then thereafter, we also make allegations we have written to Millards. We have written certain. Look, we have in page number 87 Millards. We have written many letters to Millards, even the EPTCL also. That the kind of clauses that are being imposed upon us by any SS Millards.
No. The question is, you see, what is happening is this. You are asking out here what? See, there's a mandamus to quash the letter dated 7/3/2024. Where is that 7/3? Where is that letter of 75? With reference, you are hereby informed that the letter of award dated demand to MS Notice so and so pertaining to supply of outsourced so and so to various installation, hence under clause 3 of the existing contract agreement dated so and so between EPA and WES, you are hereby requested to withdraw the outsourced so and so presently appointed at the various installation of APGCL as per so and so. Rightly, what is wrong with this whole letter?
No, because before that, my lords, the conciliation officer has asked us categorically that do not, my lords, in page number 78, my lord.
No, were you not the employees of Vanguard?
We were the employees of the Vanguard. working
So
in the center
once
division.
Vanguard leaves, Vanguard was given a contract for 4 years.
Yes, sir.
Vanguard leaves.
Yes, sir.
If Vanguard leaves, the Vanguard leaves along with his employees,
Along with the employee,
which includes you.
which is clause B. Subsequent to
Now,
that,
are you saying, are you going to dictate that kindly don't give it to NES?
no, my lord, we are not here to dictate that, my lord.
So you want that NES should also employ you.
In subsequent to that, my lords, NES has actually also held an interview, my lord. The affidavit to reply, my lords, they have categorically came up and said that people who are employed at Vanguard, my lord, that interview has been conducted. Interview been conducted, my lords.
Understood. Interview means what? They want to bring you within the fold of their employment.
NES.
So therefore, the question is, you say that this particular document,
Yes, my lord.
you see, NESA, Vanguard was initially appointed for a period of 4 years.
Yes.
Vanguard brought you people along with him,
Yes.
with
No,
them.
Vanguard. So basically, my lords, what has happened that if we see the actual arrangement legally, actually Vanguard brought us. But however, my lords, earlier there was another contractor, there was Robocops. So basically, when they left, we used to retain our job in the same site. The contractor is just changed, the worker did not change, my lords.
No, that is immaterial. Unless because when Vanguard came in, Vanguard also brought them within your employment.
Yes, ma'am. That is an admitted factor.
So therefore, once Vanguard ceases, it is being given to somebody else. Tell me, can APGCL then direct that look here, you have to keep the employees under Vanguard also under your employment? Can it be a part of the contract? No. So therefore, they have to categorically say that kindly remove those so that it clears the way for NESS to bring their employees. It's a different thing. Taking into account that you people are used to doing out there the outsourced jobs out there. So therefore, you want to come within the ambit of that, of the employment of NES, so that you can continue your services there.
Yes, madam. So the factual
So your challenge to the communication dated 7/3/2024 has no legs to stand.
Yes, madam. As of today, it does not, madam, because NESS already is in the picture, madam.
Now, you are asking a writ in the nature of certiorari and mandamus to the respondents to bring on record the employment agreement by NES Limited and quash the same.
Yes, madam.
Why?
The reason being the same, madam. Madam, had it been the case, madam, that the employment agreement which was being given to us, had it been the case, madam, the factual aspect of the case is that, as I've been briefed by my client, madam, that had it been the case that we have ceded to the employment agreement that is given by the NES, madam, would have been employed by the NES. That was being told to us. Well, the reason, my lords, that we did not at the first instance, my lords, came to the court and did not continue in the NES because, my lords, because of this unconstitutional agreement that was presented for us.
So therefore, your quarrel is with NES.
NES because, my lords, because of the inaction of the, my lords, APGCL, my lords. Reason being I'm saying, my lords, is this is a very narrow argument that I'm trying to make with this, my lords.
You want that the APGCL should also control how NES appoints its employees.
No, my lords. Because, my lords, in the general terms and conditions, my lords, they have actually set out a lot of standards that what the workman that the employee that will be there employed, what is height and everything, all these aspects have been there, my lords. So when they have said that they would apply to all the labor laws, now here we are the workmen who are coming and saying, employees who are coming and saying that, my lords, that the contract that is being asked by the NES to sign, my lords, is unconstitutional in nature. Now, my lords, APGCL categorically does not take any stance and say that this employment agreement is an internal matter.
No, that was not a part of the terms of the agreement.
My lords,
You see, APGCL enters into a contract with NES on the basis of some tender terms.
that terms and conditions, my lords, will
Now the question is, NES comes in, is being issued the work order.
yes, my lords.
Now you want APGCL to say that whatever terms are there, it's okay in the terms tender document or in the contract entered into, but you also have to look into it that they duly comply with that these terms, onerous terms, you cannot put it.
Yes, my lords. We want to
You
say
want that for them. That means you want this court to direct APGCL to resile from the contract.
Plus, so at least direct the NSS that such, my lords, unconstitutional agreement should not be there. My lords, because I just want to bring just two clauses, my lords. Just two clauses. My lords, in tender document, in clause 22, my lords,
Page
page number 7, my lords,
of
a tender document, my lords, that I have,
which one?
that I had the pre-copied.
This is a work order.
Work order.
That?
Yes, my lords. Page number 7, 22, my lords.
Yes.
My lords, if I may read it, my lords.
Ah.
The contractor firms are able to provide 2 pairs of uniform of their own and livery items such as ammunition boot, web belt, army card, so and so, etc. The seasonal livery items such as jerseys, jacket in winters and raincoats shall be provided by the firm. The agency shall also have to provide mosquito net and blanket to security personnel supplied by them. The cost of above livery items shall be borne by the contractor and the APGCL shall have no liability whatsoever in this account. The color and pattern of the uniform shall not be identical to those of APGCL security personnel. However, the cost against the supplied livery items should not be deducted from the wages of the security guards. But let's, in this thing, the uniform and all these aspects should not be deducted from the account of the security guard. But let's, the employment agreement, which they have tried to, the NESS is trying us to sign us, they categorically says, in page number 81.
Yes.
81, my lords.
How can one read it?
My lords, in affidavit in reply, my lords, I have given a translated version also. In that is in my lords, page number 145 and 146.
Huh?
From 145. In affidavit in reply, my lords. I have given a translated version also. Time version.
Ah. Yes.
In my lords, in 146.
Clause? Clause?
Clause 12, my lords. 146 clause 12.
Okay. So there they will be deducting it.
They will be deducting it.
Now, have you brought this aspect to the attention of the APGCL?
Yes, we have brought everything.
Yes, APGCL, why you not asking your contractor to be very careful on this?
In fact,
Have you
Lord,
given a copy of this document to him?
Yes, sir.
Have you given a copy of this document to him or not?
Brought it.
This document which you have just placed it before me, have you
Send it
given
to-
a copy to him?
no, I'm not aware of this. My lord.
Is it only for me?
Here, just print it out.
Kindly come to paragraph clause 22
My lord.
of this document. The last line, however, the cost against the supplied library items should not be deducted from the wages of the security
This
guards.
is the lordship.
Okay?
My lord.
So now what they put it out there in this agreement, the security personnel must have 2 complete sets of uniforms at all times, and these shall be supplied by the company to its workers, employees on payment of its price on actual as and when required.
Well, that can be taken care of because NESS is
So
before. your lordship.
therefore, I therefore suppose,
Hmm.
as regards Vanguard, this we can't look into this. As regards all these issues, you submit a representation to them, APGCL. What it goes against what the NESS is doing, which is against the work order which have been issued, and they will consider.
Have, my lords. We have actually, my lords.
No, you are not. This document is not here. Till now, you have not brought on record this particular document. He also doesn't have that. What is this additional affidavit? Today is fixed for final disposal. No, Mr. Counsel, first of all, APGCL can very well look into this aspect.
Well,
Submit your representation properly. What you are asking, you cannot ask APGCL to change the terms and conditions which they have entered. Now APGCL says, then look here, asking the company that look here, you will provide uniforms and all, and kindly don't deduct it from their salary. This is their stance. Now what you are trying, what NESS is doing, is saying that we will provide you the dress, but you have to pay the actual cost. So this is a thing which goes against the directions of the work order issued by APGCL. APGCL can very well work out with its employees in this regard.
That being one aspect, my lords. The other aspect is, my lords, even if the work order, my lords, will say A, B, C, my lords, then, my lords, NESS, while making an agreement with employee, they come in D, E, and F, my lords. And D, E, and F are, my lords, violative of the, on the prima facie on the face of the record, my lord, violative of the constitution. My lords.
Which one?
My lords, para number, my lords, 9.
On admission on purely temporary basis to NES as its worker, no body can form or no part can take association as per the company rule, and if they do so, they shall be immediately expelled from the company.
Yes, my lord. So that is purely violative of 19(1)(c), my lords, of the constitution. They cannot part, neither they can form any association, nor they can take part in any association, my lords. That being one aspect. My lords, then para number 11, my lords.
So this right to form association is under 19.
1C, my lord, fundamental right.
Who gives that right?
Constitution.
To whom?
To all the citizens.
It's a right.
Yes, my lord, fundamental right.
Let's read it. Article 19(1)(c). Constitution conduits. Yes.
Protection of certain rights regarding freedom of speech, etc. All citizens have right, standing directly similar, to form association or union or cooperative society, my lords.
Now, this right which is being given, can you enforce it against a private?
Exactly, my lords. That's what I'm saying, my lords. Fundamental, because, my lords, private, if they are, if they are functioning the offices in the private, my lords, that.
No,
how
can
they
you
get funded.
can you enforce it against the private? My only question is that.
Yes, my lords. If they are, my lords,
Show me a judgment on that.
exhibiting
Where-
the function of a state, my lords. If they're exhibiting the function of a state, because all they're doing is.
No, they are not yeah, but I'm asking you, can you enforce this right?
Look, there are certain exceptions to, my lords. It is
Yes.
actually the state, my lords. It will fall back upon 12, my lords, that it will be against the, my lords, state to enforce these fundamental rights, my lords. But however, my lords, with the canon of judgment which says this, my lords, when a private entity is also exhibiting the role of a, my lords, in a public organization, Because then even the fundamental right can be brought against those entity millets.
Where?
Yes, my lord.
Which judgment?
That I have not.
No, you are not prepared that. Show me which judgment.
That I have not got.
What you are saying, the basis of this law is this, that a person, a private entity exercising public functions, then in that regard, a writ may be issued against them. A writ may be issued. It's a different thing from enforcing a fundamental right qua a private citizen. Tomorrow, Mr. D. Nath, on a private aspect, comes up and tells you that, look here, you cannot come inside the courtroom. On a private basis, you cannot go to the court. Can you enforce the fundamental rights qua him? No. But if he says tomorrow, in the capacity of the senior government advocate, and looks here and says that, look here, you cannot come. It's a different aspect.
But there are further examples.
Because then I can very well ask him that, look here, you cannot stop him from entering or forming an association out there. Because this is a right qua him. Issuance of a writ when a person is discharging a public function is different. But this is not there. If you see the St. Mary's judgment, the Supreme Court distinguishes this very aspect and says, look here, if he is anything as regards the salary of a private teacher, although they may be imparting education, which is a public function, anything wrong with while imparting the education out there is justifiable under Article 226. But the salary is being not paid to the teachers out there of a private school is not within the ambit of Article 226.
That is the benefit that is accrued in this case. That intelligible differential that is being brought by your lordship, that is foreign from the lordship millets. In this case, I will submit these millets. Here we are talking of millets. Here we're talking of millets, a workman actually work under as a private individual with private contractors millets under various authorities which are critical to the functioning of a millets of a entity of a state millets. Now, millets, in this case, all this I want to submit is this, that all their grievances, if millets, if I say what cannot be done indirectly by the millets, directly by the APGCL, by employing the contractor, and then millets having inaction on the part of the APGCL, or not millets even calling for the records or even commenting upon millets this allegation millets. What they're trying to say is this, that all your grievances millets, there will be no redressal. Because all that I want to submit is this millets, that when authority millets, when workers were working under the private under the state millets, not directly but through contractor millets, if they're not allowed to form any association, plus that is also curtailment of the fundamental right millets.
By whom?
Millets indirectly by the state millets.
No, they are not saying and imposing anything upon them.
That's what I'm
They
saying.
don't have this association.
That's what I'm saying, millets. If millets they work.
No, you see, you have to understand this. You are mere employees of a private company. The private company is being engaged by IPDCL for the purpose of providing the security guards. You are asking that you have to be treated in a similar manner as if you are an employee of the APGCL. Kindly forget this. This is not what it is.
As I already stated, millets, if let's say millets APGCL has come with a contract of putting condition of ABC millets with millets with the private contractor. Millets, in addition to that, if the private contractor comes with another D, E, F, and G millets, which are violative of, which are prime facie not incorrect millets, or violates the constitution. I say millets, they may not be always strictly under the ambit of millets, the work order millets.
What does this Private Security Agency Regulation Act 2005 say?
So this is the act that I had. So, my lords, Section 9 is my lords, standard of physical fitness for security guards. And section 15 is
Well, where is the full set of this particular document?
so this is the full set, my lord, BGCL tender, my lords. Actually, my lords, when I-
Mr. Counsel, first of all, if you don't know, don't make the submission. Kindly see annexure. That's serial number 5 of that particular document. Enclosures, duties and responsibilities of the security supervisor, security guards. Where is that?
Sir, this is a public document which I got, my lords, from the downloaded from the internet, my lords.
Understood. Where is the annex 1?
That was not there, my lords, the public document, my lords.
Who come up with all this? This is a tender.
Yes, ma'am. Work order, my lords, they have. given
Where is the
in
work order?
Work order, they have given in the affidavit in opposition, my lords.
Where is that? Page?
Page one,
number 120.
129.
What is PSA?
Private security, Private Security Agencies Regulation Act.
Mr. Nath, kindly
Lord.
come to page 122.
One, lodge.
After paragraph 8, read this as may be inferred from the above.
As may be inferred from the above, APDCL is committed towards upholding the rights of all our employees, workers, and ensuring compliance of all labor laws of the land. Further, taking a considerate and humanitarian
Now,
view towards
taking into account that letter, those sentence,
Lordship.
are you therefore not required to look into it, the grievance of those persons concerned, that they are not being allowed to form an association?
But here, Lordship, first and foremost, Lordship will see they are as on today not in employment of anyone. the petitioners, they are not in employment of anybody.
They're not employment.
No, they want to enter the employment of NESS now. Because they said that NESS has put a condition, they are giving us an agreement that is to be signed, they are not agreeable to sign that, that is why they have challenged. If they don't challenge, NESS will not take them. Respondent number 10 is before your lordship. We have, my lord, to supply security persons, we have entered into contract with NESS. NESS in the page 129, we have asked them to supply 61 persons. We have in our affidavit, we have said that immediately you supply this, and later on, as on requirement basis, we will give you requirement order, and accordingly, we have to make the supply. But to that effect, in the writ petition, they have annexed that an advertisement was issued by the NESS, that lordship will find, and they are agreed by that. Page number 82. Page number 82, they said that now the NESS have issued an advertisement to fill up some post of security guard for holding a selection. And while they said that while participating in the selection or taking the job of NESS, they are giving us and they have given us an agreement which is to be signed. That agreement is violative of they are not agreeable to the conditions of that agreement. Therefore, they are before this honorable court. Basically, my lord, the NESS for taking them in employment, they have put those conditions.
Are you still in employment of anybody? Are you?
Exactly countered that argument, my lords.
Ah.
Before I submit, my lords, with facts, my lords, if my learned counsel is
Para,
aware of.
then what is their prayer number 5, my lord? Prayer number 5 and 6?
Submit to that, my lord, allegation, my lords, that we are not in employment, my lords. I have categorically stated in my affidavit reply. That one simple submission, one line, my lords, that my learned colleague is very much aware that we did not go to NESS or not, but they will never come with this employment agreement. With that, they will say they never know about this. They are not aware of the employment agreement, but they were very much aware that whether we.
No, my question, no, Mr. Counsel, wait, no, Mr. Counsel. Is any member of this association,
Yes, page number 150 minutes.
is any member of this association of respondent number 1, petition number 1, in employment of NESS?
Page number 150 of the Mallard's affidavit in reply.
150. 150.
So that was Mallard's, my learned colleague was referring to Mallard's, this is of 12 and 14 June.
Yes.
Page number 150 minutes.
150 report.
Interview on 7/8/2024 sell from security guard for future vacancies in APGCL project sites exclusively for the person who work under VSS, Vanguard Security, up to 30 June 2024, my lord.
And did not appear in the list of
Yes.
interview with reference there with the employment, the last list 1, 2, and 3. Now on finding requests from different circles to give them one more chance of company, they had to hold another interview on money. Now what is this?
So subsequent to that, my lords, they have actually, my lords, selected candidates, my lords, in page number, my lords, 150 to 153, my lords.
Are you there?
My lords, there are some people of our association, my lords. My lords, 150 to 150.
Who are the people from your association?
My lords, that I have to figure it from my plan, my lords, who are the people in the association. But these was, my lords. So
Are these
basically-
people, you are part of your association? These 39?
NESS appear करना है.
So basically, yeah, so all these people who worked with VSS Millers were part of our association, Millers. So this was, Millers, subsequent to what my learned colleague has said, Millers, that we were not part of the NESS Millers.
Must sign it with the terms and conditions of the NES before joining. Page 225, this is otherwise 152.
And they say, Millers,
Now,
persons-
are these persons a part of your association?
Yes, Millers, some of them are, Millers.
How do you know?
That I have to.
Where is your association list?
Association list is, Millers.
You are a registered association. Where is the association list? Your number 2 is not a part of it.
Of our instant repetition, Millers, we have given a list.
Huh?
Look, all those people who were working with DNSS Millers were part of our association.
Where is your statement? Mr. Counsel, you filed this writ petition on 27/6/2024.
Yes.
This interview was held on 7/8/2024. Then,
Yes, but subsequently when they brought.
so
the-
that means some of your people from your association who are there, these 40 people, 40 or 45 people, have bifurcated from your association.
Basically what has happened has been told to me, Manoj.
So you don't have that association any further.
No, Manoj. So basically what has happened subsequent to that, Manoj, is this. That there is a site in Karti along, then there is a certain site in Manoj in Namrup also, Manoj. Most of the people in the Karti along have been.
No, Mr. Counsel, you have to understand. I fixed this matter for final disposal. You have already taken such a long time. I'm giving you some more indulgence only for the purpose that I want to finish up this matter. There are other matters which require interpretation. But it seems that you are not ready with your matter. First of all, you have filed this affidavit bringing some people who have now been here where it has been categorically mentioned that he has to sign the agreement. So your cause of action therefore arises on the basis of this select list which was published on 7/8/2024.
Further cause of action. Further cause of action.
There is not a further cause of action. It is only there it has been mentioned that you have to sign the agreement. Where is it mentioned earlier that you have to sign the agreement? So therefore, your agreement to sign the agreement only comes at page on 21/8/2024.
Malaj, earlier, prior to that, Malaj, when NESS entered into the Malaj, in the working of at the site of the Malaj APGCL, prior to that, what happened, Malaj? We have made certain representation, Malaj, to the conciliation officer as well as to APGCL. Malaj, when NESS had thought of Malaj, because all of a sudden they did not bring Malaj the workers from outside. Because they first contacted us, the members of our association, that this is the agreement that you have to sign, Malaj. So that is also further cause of action, and we have sworn that in our affidavit, Malaj.
What are you asking for stay? 15/10/2024? What?
No, that interim was not given.
Huh?
That interim was not provided to us, Malaj.
Where's the? You should have been more clear on this, Mr. Counsel. What is your name?
M. Burman.
Huh?
Manas Burman.
Manas Burman. You have to be more clear on that when you bring it. Means you want to forego the interview process by this IA. And those persons who were earlier employed with VSS, Triple S, would now be allowed to function with NES. This is your prayer in the IA.
No, IA is a different Malaj. They will ask for vacation of our quarter that we have Malaj there.
No, this IA,
Yes.
IA 3705.
But the Malaj quarter. that
What
we were
quarter?
occupying, Malaj.
Now,
They were
please to
occupied-
stay the notification dated issued by respondent number 1 and direct respondent to 10. What is that notification?
They are occupying the official quarter. We said that you vacate the quarter, then Malad, page number 18 in the I.
Have you thrown them out or not?
File objection, Malad. Objection we have filed. That they have no right because they are not in service, so they cannot occupy the quarters.
There's no given, throw them out.
Lodge.
Don't need to give a reply.
Annexure 2, page 18.
I think we dismiss this page.
Malad,
Petition is back.
basically what
These people, you see, Mr. Counsel, I'm very upset with you because of this. You have come up with this particular document in your affidavit, and you don't know whether these 80 people or 30, 40 people are part of your association or not.
Basically, what has happened, Malaj?
Now you have spoiled the time of this court. Isn't it kept today for final disposal? Then
Look, I have been told that they are part of our, they were part of our Mallards association. Look, for example, the petition number 2 Mallards. In page number Mallards 157.
uh,
157, okay. Board
Yes.
It's not for our Mallards.
where?
No,
14.
Mallards.
Not
They said that-
deployed on date, BA pass, so and so. List of area documents not submitted. Okay. 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 So this person is there. So therefore, Mr. Mr. Nath, one person also, the petitioner number 2, name, he has been selected, but requirement of submission of these documents. Now this happened in 2024. Now are you getting your salary? Okay, so none of these people joined.
Because they were asked to Mallards, but however, some people joined Mallards in Karbi along, as I said, Mallards, were part of our association. But they said that they are not deployed as on date Mallards.
Who?
This, let's say petition number 2 and some other petitioners also.
They are not deployed.
Yeah.
You have problem in submitting the agreement,
Agreement.
not to form an association.
And other one.
What others?
That we have to give for uniforms also.
A uniform
And
and
Mallards, we have to submit 1 wage for 1 month wage for Mallards for administrative experience. That they have written in.
Where?
Yes, Mallards. Mallards in 146 clause 11 Mallards.
justified grievance problem, each worker to be joined newly shall have to deposit an amount equivalent to 1 month's year to the company to meet the administrative charges before joining. Thereafter, in the next subsequent second, amount of such fees have to be deposited at a reduced year of 1 month's salary subject to continuation. So it's like a security deposit.
Not security deposit Mallards, but it does not say that it will be refunded Mallards.
Who is appearing for response number 10?
They have not entered appearance. We have given justice service also.
Why? Service is done.
Justice service also.
So you have problem with this regard to 12,
9, 11, 12.
9, 11 and 12. These are the three now. So we dispose it off. You look into these aspects.
But
More particularly because you see first, you are committed to take into account this lawyer because you see petition number 1 is an association. Any of them, I'm not saying about petition number 2, but any of them may have a grievance. It's an association.
Lots.
So any of the members who are there. So as you are also committed, the first is as regards number 9, on purely temporary basis as a year, so and so, they cannot form a part of the association. Whether it would be within the ambit of you to say, put one of your contractors to impose such onerous conditions. We'll look into this. Second is as regards salary. You are asking these people to work as Surya and now you are asking to deposit of 1 month salary prior to
no,
that.
these are all conditions imposed by the
Understood.
contractor,
But
not
you are also,
employer.
as you say in that particular document which I read it to you,
Lot of, the tender
yes,
conditions.
that you have to look into committed for them.
No, that is in respect of the earlier grievances raised by the employees before the.
It's okay, but it's there's
and-
quarrel with that. This is your document wherein you categorically say, as may be inferred from the above, APGA is committed to upholding the rights of the employees.
But at that point of time, they said that some dues were not paid to us.
It's
That
okay,
has been
but
paid.
you are committed being the contract, you are, just for example, as per the Contract Labor Act, if the other person doesn't pay, it is your bounden duty to make the payment. if there is any deduction to be made, if the deduction is not being made by that particular person, it is your duty to look into.
In fact, the work order,
These are works which are actually duties of a sovereign nature. So these duties which are of sovereign nature means manning the sovereign functions out there. You are outsourcing it. Security guard is a sovereign, it's actually a security guard is a sovereign function. And you are outsourcing it. So looking at so and so, will pay you this amount. But it is also impoundment duty upon you to look into it that these are also respected because you want this labor laws. Just for example, you have put it in your own tender condition. Then look here, you are not going to charge them. So you take it up with them and then negotiate and finish it up with them and consider their case.
That-
You submit a representation as
that
regards
will
9,
be, that will be, my lord, in respect of the persons who are in service with the.
Oh, yes, that
Any-
only those who are in
Yes,
service.
Yes, not with the NESS association, my lord.
Huh?
Not with the association.
No, not as a, only those persons who are members of the association and in service.
Yes, my lord. Those are in service. Lordship.
So those persons who have been selected and in service,
Service, that's true.
they will be entitled to this benefit.
Yes, yes,
They are considered. Therefore, you are to look into it.
My lord.
And tomorrow, just for example, if I may say, tomorrow in a case, a particular person concerned, you say that yes, these are onerous terms which you have imposed for which they have not signed, although they are selected. You may very well ask NESS to look into this very aspect of the matter. You see, these are labor disputes which needs to be resolved. Like
In fact, the projection made in the writ petition is that you, a direction has been sought from this honorable court to allow them to serve in NESS. But that is
I'm
their-
not.
their
I'm
fair
also
point.
not directing that.
My lord.
That aspect, I'm not doing that.
Because-
I'm only directing, they will submit a representation as regards clause 10, 9, 11, and 12 or
Lord-
whatever may be.
Lordship.
You will look into it. And as to whether, and then as per your terms and conditions and keeping into account the welfare of these people, as to whether these are onerous, and then take it up with your contractor.
Yes. In
And the contractor, because you are, in spite of notice, they have not represented. And the contractor, thereupon, you can very well give those terms and conditions which you have. This is between you and the contractor.
Yes, that as per NIT conditions, they have
Nothing
to.
more than that.
My lord.
I'm not asking you that you employ them. No.
That-
But these certain terms, if it is onerous, you being the custodian or you being the main person and you being the state, to look into it, your contractor does not violate these labors.
My lord.
Let me come back. I'll dictate it. Nothing more than that.
Lord.
Heard Mr. M. Bormon, the learned counsel, appearing on behalf of the petitioner. Petitioners. Mr. D. Nath, the learned standing person, standing counsel, appearing on behalf of the respondent numbers 1 to 4. Government, PKS Burba. He appear for the government also, na? State of Assam. PKS Burba, who appears for the respondent number 5, 6, 7, 8. Mr. So-and-so appears for the respondent number 9. 9. None appears on behalf of the respondent number 10. In spite of service being affected. Pusto. The petition number 1, which is an association, which is a trade union, registered under the Trade Union Act 1926. Pusto. The petitioner number 2 is the president of the said trade union. the petitioners contend that its members are all outsourced security guards employed in the Assam Power Generation Corporation Limited, bracket APGCL. It is the further case of the petitioner that the APGCL, in order to provide security to various installations, provide security to its various installations, outsources the security guards by a tender process amongst government registered security agencies. The members of the petitioner number 1 earlier, members of the petitioner number 1 are employed by these government registered security agencies on the basis of the contract entered into by these government registered security agencies with APGCL. At the time when the writ petition was filed, on 27/6/2024, the grievance of the petitioner were that the respondent number 9 did not pay the dues to the members of the petitioners association, petitioner number 1 association, union. This grievance, however, no longer survives to be adjudicated in a writ proceedings, taking into account the stand of the respondent numbers 1, 2, and 3, who claims that the respondent number 9 were duly paid all their dues, and the respondent number 9 on affidavit stating that the members of the petitioners union have been paid their dues. Be it as it may, the dispute presently, which requires an adjudication, is regarding certain onerous terms being imposed upon by the respondent number 10 while in order to employ the members of the petitioner association as security guards in the installations of APGCL. Full stop. It is the submission of Mr. M. Bormon, the learned counsel appearing on behalf of the petitioners, and submits that though the members of the petitioner union have been called for interview and being selected provisionally, but they have been asked to submit an agreement containing unconstitutional terms, and more particularly, reference has been drawn to clauses 9, 11, and 12, which not only violates the mandate of Article 19(1)(c) of the Constitution, but also violates Article 23 of the Constitution. The learned counsel further submits that clause 12 is even contrary to the tender conditions which were set out by the APGCL dated 6/6/2020, APGCL in its NIT dated 6/6/2023, and more particularly to clause 22. Pustam. This court have also heard Mr. D. Nath, the learned standing counsel of the APGCL, who submits that the terms of the employment between the respondent number 10 and its employers are to be regulated as per their employer-employee relations, to which APGCL have no say. He, however, submits that as the APGCL is a state within the meaning of Article 12 of the Constitution and is committed to read the document, APGCL's letter. Somewhere I found
Page 129.
one
129.
document which I was asking you to read, na?
That document, my lord, is 122. After para eight.
122, na?
Yes,
Ah.
part of the FL.
কি লিখিল last? And Article 12 here. Is committed towards upholding the rights of all employees oblique workers and ensuring compliance to labor laws of the land. the APGCL can look into the said aspect if there is any infraction to the constitutional norms as well as the terms of the notice inviting tender dated 6/6/2023.
Page 131, we have made clear.
He, however, submits that the said should only be applicable to those persons, those workers, those members of the petitioner's association, union, who are presently under employment with the respondent number 10. Pusto. This court have heard the learned counsels appearing on behalf of the respondent number 10, 9. Pusto. This court have heard the learned counsels appearing on behalf of the respondent numbers petition, the respondent number, the respondent, all respondents except the respondent number 10, who chose not to appear in spite of notice having been effected. The grievance of the members of the petitioners pertains to clause 9, 11, and 12 in the agreement taking into account the said clauses are reproduced hereinnder, page 219 of the slide. A perusal of the above quoted clause, more particularly clause 9, shows that an employee cannot form or take part in any association as per company rule. And if they do so, they shall be immediately expelled from the company. At this stage, this court duly takes note of Article 19(1)(a) (c) of the Constitution, which confers rights upon every citizen of the country to form associations or unions (or cooperative societies), and the reasonable restrictions which can be imposed in terms with Article 19(4) when such operation imposes or prevents the state from making any law imposing in the interest of the sovereignty and integrity of India or public order or morality, reasonable restrictions on the exercise of rights conferred by the said subclause. The members of the petitioner union, even prior to participating in the recruitment process initiated by the respondent number 10 are already members of the petitioner number 1 union. It is the opinion of this court that the respondent APGCL, being a state, whose installations are required to be guarded have, instead of employing persons within their company, have sought to outsource them through private agencies. It is also very pertinent to take note of that the respondent number 10 is a government registered security agency. And as such, they cannot, and as such, it is incumbent upon the respondent APGCL as well as the respondent number 10 not to impose such conditions which would be contrary to the constitutional rights guaranteed under Article 19(1)(c) of the Constitution. It is the opinion of this court that clause 9 of the agreement prima facie appears to be contrary to Article 19(1)(c) of the Constitution. Clause 11, next, as quoted above, stipulates that the selected worker oblique employee, when he joins, would deposit an amount equivalent to 1 month's salary to the company to meet the administration oblique registration charges before joining. It is relevant to take note of that from the materials on record, it is seen that upon making payment to the employees by the registered government contractor, the same would be reimbursed by the APGCL. It is the opinion of this court that to use the salary to use an amount to be deposited by the employees to get the bills cleared from the APGCL is not only arbitrary and irrational, but also violates the mandate of Article 23 of the Constitution. It is therefore the prima facie opinion of this court that clause 11 of the agreement, as quoted above, requires a relook by both the APGCL authorities as well as the respondent number 10, more so taking into account that the APGCL authorities are committed as per their own stand to fulfill the two compliance with labor laws of the land. Full stop. It is also the opinion of the court that the clause 11 prima facie also appears to be a classic case of unfair labor practice. Next. This court further finds it relevant to take note of clause 12, which stipulates that the security personnel must have two complete sets of uniforms at all times. And these would be supplied by the company to its workers, employees, on payments of its price on actual as and when required. Full stop. At this stage, this court finds it also pertinent to take note of the notice inviting tender dated 6/6/2023 issued by the APGCL, wherein clause 22 is of relevance taking into account its correlation to clause 12 of the agreement. Clause 22 of the said agreement, said notice inviting tender, is reproduced hereunder. From a perusal of the above clause, it would be seen that it is the duty of the company, contractor of the firm, to provide 2 pairs of uniforms. Yes, how does it apply?
The broad aspect, uniform and livery items.
No. Contractor firm shall have to provide initially 2 pairs of uniform of its own and livery items such as ammunition, boots, so and so, so and so. However, the cost against the supplied livery items should not be deducted. Only livery items, not for clothes. Then how does it apply?
Because statement are not necessary.
Understood. A perusal of the above quoted clause categorically reveals that what are the livery items? That is, ammunition boots, web belt, army cut ankle, beret caps, whistle cords, hunting shoes, PT shoes, kukri, sticks, torch, lights, etc. It further reveals that the seasonal livery items such as jersey, jackets in winter, and raincoats in monsoon shall be provided by the firm. Further to that, it is also mentioned that a cost against the supplied livery items should not be deducted from the wages of the security guards. The question therefore arises as to whether the uniforms to be provided would come within the ambit of the library items as mentioned in clause 22 of the notice inviting tender. First, it is the opinion of this court that this aspect be decided by the APGCL, taking into account clause 22 of the notice inviting tender dated 6/6/2023, along with clause 12 of the agreement, which the petitioner, where the members of the petitioners association union are required to be submitted. First, accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The petitioners herein are directed to submit a representation to the respondent APGCL, and more particularly, and the respondent APGCL, and the general manager, human resource, managing director or general manager? Mr. Nath, managing director or general manager? Managing director.
But the
And the respond number 2 and 3
work order has been issued.
are specifically directed to look into the said representation.
GMHR. GMHR.
2 and 3
Lot 2 and 3.
directed to look into the said representation only insofar as the grievance of the petitioner as regards clause 9, 11 and 12, and taking into account the observations made herein above. Number 2. This court makes it clear that the judgment that makes it clear. Now, this court have duly perused the affidavit, the affidavit in reply filed by the petitioner, dated 24/11/2025, and the list of security guards deployed and paneled, dated 21/8/2024, enclosed to the said affidavit in reply. From a perusal of the said documents, the said list, it appears that some members, some of the persons have been deployed while others have not. Next, another. It is that both the respondent numbers 2 and 3. No, full stop. Yeah, full stop. It appears that some have not been deployed, taking into account that these persons have not submitted the agreement. Next. Accordingly, this court therefore directs that upon the decision so taken by the APGCL on the representation, the APGCL would be at liberty to direct the respondent number 10 to decide as to whether those persons who have been provisionally selected can be brought within the fold of their employment as outsourced, as security guards in the various installations of the respondent number 10, of the respondent number 1. First, next, the entire exercise be carried out within a period of 3 months? 3 months from the date a certified copy of this judgment is submitted to the respondent number 2. No more.
We did not receive it, madam. That may be added to the submission. That we did not receive the statutory dues from respondent number 9. Only that may be added as an oral submission, as my submission, madam.
What?
That we, as I already submitted that, madam.
itu ya, ada lesson dia ya. Last slide. As already stated here in above, there are disputes. There are disputed questions as to whether the petitioner have received the entitlement from the respondent number 9. And this very aspect cannot be adjudicated in a writ proceedings, taking into account that that this court may have to go into this court may have to dive into intrinsic evidence. Liberty is given to the members of the petitioners' union who are deprived to approach the appropriate forum seeking such redressal. I stands closed. And you, whoever it is, vacate. Ekon logai dibo deই. I stands closed.
Lordship.
I ekhonot likhibo, heard Mr. So and so and so and so so and so, taking into account the above judgment passed taking into account the judgment passed here, this court is not inclined to pass any directions as has been sought for in the writ petition,
Lordship.
in the interlocutory. Where is Mr. R.R. Gogoi? Oh, you are there. You got your records?
Records are there, my lord, but records mostly pertain to the fact that the works have been awarded to other contractors who have finished it also, my lord, and it has been
I'm
handed.
not on that.
Yes.
Simple question is only one aspect. This is a trade from here to here. The trade is only on one thing. Did you issue the notice to him prior to doing it?
Yes.
Because you say that you have done so in your affidavit. They say that they have not received it. That's it.
Yes. That, my lord, the answer is there. This has not been incorporated in the affidavit, my lord, but we have it as an instruction that petitioner physically petitioner was not available in his office. So what they say is, my lord, they send it through a WhatsApp message because his office he was not available, and that has been mentioned in the writ petition also, man, that they had received it in their WhatsApp, in their own writ petition, because in the address that was given by them, that has been recorded in the work order also, my lord, in that address they were not available. So that is why it was done through that means.
They came to learn later on.
Paragraph
This is their
7, your lord.
No, in the affidavit they say kindly see paragraph 11.
Paragraph 11 of my writ petition.
Where's your senior?
Senior's mother is admitted in hospital.
Chalo, we adjourned it because I'll dismiss your petition. I won't dismiss it directly. I'll say that you can go to the civil court claiming that. That is what I'm saying there, because but I think it will be better if your senior is there. Because her case, I remember, she said that yes, there was some lethargy, but they were given an extension by the junior engineer. And prior to that, they have cancelled it. And you say that you have cancelled it because the chief engineer calls up everyone and says that work has not been done. It's yours then. And therefore you issued the notice. Nothing has been mentioned in the affidavit. And therefore I sought for the records. Where is it in the records? It is mentioned that you have sent. And what is this WhatsApp message? Show me the WhatsApp message.
This copy I have.
Show me. Is this your official number?
This
Is this the official member?
sender is, my lord, office of the executive engineer.
Huh?
Official number, there's no official mobile number as such.
How many works? This was sent on,
16.
this is 4-3, sent on 6-3. 4-3 was sent on 6-3.
Yes.
And then on 13th March. In the meantime, you terminated on 11th March. Huh?
Yes.
As per your terms and conditions, whether it is given like that. And why one notice against everything?
It comes under the same division, ma'am.
One division, one notice will do. Terminate everything. 5 works, na?
Yes. 16 words.
16.
16 words.
Huh?
16.
16 works. My goodness. But in the meantime, the work is complete.
Yes, my lord. Other contractors have performed the work.
And the amount has been forfeited.
There is no mention of a security deposit, ma'am.
Oh, then work has already been done. Your matter has become infructuous. Let's see your prayer, madam. Read it.
Order dated 11/3/2024 and directing and commanding the respondent to allow the petitioner the reasonable time to complete the balance work previous 5 projects as mentioned in the interim order dated 11/3/2024 and pass further ordering.
How can you, if the work is already completed, what remains? Your entire relief is gone for a 6. Isn't it? How do I know that the work is completed?
Records, my lord, I have with me. Where
You
other-
filed an affidavit.
Affidavit can be filed, my lord.
1 week. It's parted. 1 week. We'll have it on 2nd, 3rd. Why? Mother's illness will continue till 3rd. No, you're fixing a date. You say that the mother, because of that, your senior is not here. Because of the mother's illness. But how do you fix it on 3rd that it will be okay? Unless it's a viral fever. Tell me. We'll have it on 3rd. Your petition will become infructuous only when he files that affidavit. Have it on 5th then. Let the mother also get okay. On 5th. You file that affidavit. To that effect, the work has been completed. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. I. Botaku, the learned counsel who appears on behalf of the PHA department. The petitioner have challenged the order dated 11/3/2024, whereby various works which were issued to the petitioner were terminated and steps were being taken to be carried out through other agencies. The petitioner has assailed the order dated 11/3/2024 on the ground that the same was not, that no notice was received by the petitioner, asking the petitioner to show cause prior to cancellation order dated 11/3/2024. Mr. Ibu Tagore, however, submits on the basis of records that in spite of that, pursuant to the termination on 11/3/2024, the works have already been completed. And as such, the question of the instant writ petition has already become infructuous. It is the opinion of this court that the said aspect be brought on record by filing an affidavit by an officer not below the rank of what? Additional chief engineer.
Chief engineer can file, my lord.
Additional chief engineer.
Additional chief engineer.
Not below the rank of additional chief
yes,
engineer can
then
file.
chief, yes.
Even the secretary can file.
Yes.
An additional chief engineer.
Fine.
So let this matter be listed again on 5/2/2026. In the meantime, the affidavit be filed on or before 3rd of February 2026.
Obliged.
Of the pensionary benefit of the petitioner on account of misplacement of his service connection. And in the meanwhile, the respondents have reconstructed the service project, and a copy of the same has been transmitted to the petitioner. And I have a copy of it.
What?
The pension, the service book has been reconstructed. Due to non-availability of the service book with the respondent, they misplaced. So the pension was stagnant from the year 2017 after 3 days. So that was not enhanced, and the ROP was not given to it. And due to this writ petition was filed. Due to tendency of this writ petition, the respondents have reconstructed the service packet, and a copy of the same has been transmitted to the petition. And I have a copy of it. And in view of this matter, the matter may be closed with a direction option or as an observation that the area as well as the enhancement may be done. It is create a time. We need the word first.
Yes, my lord, it is very small issue.
Small issue will be very close now.
Only the thing, we have filed an affidavit to the effect that we are, my lord, reconstructing the service book. So it seems,
Where is the affidavit?
my lord, we have,
And what is Mr. B. Sharma doing?
Okay, for the accountant general, my lord, we have already sanctioned the pension, but his grievance is that the computation that was done, that was based on the pay scale which he was receiving under the ROP rules of 2010. And we have done that because that pay scale was reflected in his service book. Subsequently, he has retired and probably is entitled to the
entitled to fixation under the ROP rules of 2017. That we can do only when the service book is corrected and it is sent back to us, my lord.
It has been corrected.
That I do not know, my lord.
Only reconstructed up to that day, Lordship.
Has it been corrected or not?
Yes, corrected, 2017 statement is.
So, Mr. Bishop, I'll have a look at. I'll pass an order later on, you don't get the benefit, it would not be proper, na? He retired as on 31/12/2016.
Yes.
And as such, the ROP rules comes into effect on
2017 they were not.
2017, it comes into effect from 1/1.
It is retired prior to.
It is, annexure 9 Lordship. Was to, the order shall apply to government employees who have got over the legal system. With effect from 1/4/2016. Page 37.
Huh?
Page 37, Lordship.
Page 30?
7. Then, this to, page 2015.
Payment of dearness allowance, relief to serving employees, so and so. Revised rate with effect from 1/7 applicable to revised pay scale of so and so. Undersigned is directed to refer to the finance approval and to say the governor is to decide the dearness
Clause number?
allowance to the state government
Two.
employees and pensioners. To law, pay and pension is of so and so shall be.
146. As of 1/4/2016, they have done the connections necessary.
Huh?
As per this document, they have done it, my lord. As on 1/4/2016, but I do not know whether it has been forwarded to the office of.
No,
the
it's okay. That is another aspect, but they have done it.
Yes, they have done it.
So therefore, the updation has already happened in the service book.
In the service book.
So
Reconstructed
therefore, now this has to be sent to you for processing.
for processing.
By which department?
By PWD, my lord.
PWD. So you will send it.
Send it, my lord.
Once you send it, then you,
They will do
you are
the-
the accountant general, so you will be approving it.
Yes, but I do not know whether they would be doing it on the basis of the reconstructed service book. Whether they would be requiring the original, that I'm not sure, my lord.
They reconstructed it, they lost it.
They lost it, department lost it.
Department lost it. After sanctioning the pension, my lord, we had sent it back to the office of the undersecretary. That document is also there on record in the case, my lord. The office of the undersecretary has
How
lost
do
it.
I know all these things?
The document is there.
It is a letter lost. There is a letter to the petitioner lost by the office lost.
Where is it? It is lost?
That was lost, when preparing the pension record launching, it was submitted and the interdepartmental communications. So the PWD says that it is with the AG office and AG officer says that it is with the PWD. And that was not.
Letter con good.
It was agreed to that.
Page 52.
Page 52, affidavit 2.
It's written.
Kindly see page 45. You lost it. Easy. Easy lost.
That is what, my lord, in page 52 in our affidavit.
Your affidavit is not here.
My lord,
Page 46, something, page 46. Page 46. Around there. IP statement, etc. leave account are returned herewith for record in your office. The AG office says that it has been sent to the Department of PWD. So both the department tried to trace it out. And finally, under the instruction of the AG office, they have prepared it. In view of the above, it is therefore requested to submit the submit.
Then the next page, well, page 53, we again directed, the government directed the chief engineer to reconstruct, my lord. So that is what reconstructed, my lord.
It is present in the report.
Okay, now the chief engineer reconstructed it. After reconstruction, where is that reconstructed? Yeah, this one? Isn't it?
That fix it is reflected, my lord, as of 1/4/2006. Last page of the branch.
Initial pay fixation, 1/4/2016.
Probably they have corrected it.
16
So now as per this, he is already given, na?
He has already been sanctioned the pension, my lord. He is receiving it, but
He is receiving
at a reduced, lesser rate.
So
my lord.
now he has to get all these things.
2017 lordship, till date, all the benefits may be given to the petitioner.
Well, let's dispose it of.
Yes, my lord. Because only the thing is that since today is a holiday, I could not take instruction regarding this reconstruction thing, my lord.
Huh?
Whether it is sent to the AG or not, my lord. That is the thing, my lord. I am not doubting this document, since my friend is, my lord, submitting it. Only the thing is whether we have, my lord, forwarded this to the,
But this copy is also marked to Rahul Dhor. Who is Rahul Dhor?
my lord, but I haven't received it. Maybe, my lord, because of his holidays, it hasn't come, my lord, to me.
Rahul Dhor, Standing Council PWD for Assam for filing. No. Your name comes with bold letters.
My lord. Yes. I have one.
Isn't it?
Duplicate service.
Or should we have it on next Tuesday
Next, my lord, I will get an instruction on
on
this.
this? Huh? Because otherwise there might be some issues. No. It is being submitted that an affidavit has been filed on behalf of the state. On behalf of the respondent number 1. It has been submitted by Mr. Ardhor that an affidavit has been filed on behalf of the respondent number 1. However, the said affidavit is not on record. The registry shall bring on record the said affidavit. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, further draws the attention of this court that in the meantime, a service book have been reconstructed in view of the fact that the office of the PWD / the office of the accountant general have misplaced the service book of the petitioner. Okay. The registry is directed to bring on record the said affidavit so filed by the respondent number 1. Mr. Ardhor shall also make an inquiry with the chief engineer, PWD, with the office of the chief engineer, PWD, NH Works, as to whether the service book have been reconstructed and further whether the said service book have been then forwarded to the office of the accountant general for refixation of the pension of the petitioner. List this matter again on 12th of February 2026.
My lord, affidavit filed on 8/12/25.
Yeah?
That affidavit is filed on 8/12/25.
8/12/2020.
ये तो पूछना जस्ट फॉर प्रमोशन का नहीं सारा के डाटा तो फुल स्टॉप कमिश्नर सेक्रेटरी फ्रॉम द एसएस के डाटा
What is the matter about?
There is a permission to the next higher. That he was in the. Of 2016, he is entitled for promotion to the commissioner secretary.
You have retired, no?
I am retired.
You're retired. Now you were already selected,
Yes, my name has been recommended.
but in the meantime you retired.
Recommended in the, before my time.
Huh?
Before my time.
Understood. But in the meantime you have retired.
S40, these are affidavits there. My name is reflected in
Page? Page?
Page 41, the affidavit. That I was on that. My name has been recommended, but not commented. But whether they have, the roster upon has been maintained or not, that they have not mentioned what's in the affidavit.
What is your name?
Gita Das, case, serial number 7,
SC.
SC.
This was recommended on
On 24/7.
2018. Then? So you want a notional promotion. What is the affidavit stand? Why they have not done it?
The affidavit, they have not, in the affidavit, page 38 of it, para 6, they incident them, para 6 of it. The regards to the environment made in program to so next to extend them to selection board in this meeting that is so while considering the cases of the cases of the promotion to the commissioner and secretary, head of ACS Kendra, decided not to follow the provisions of the reservation. As per the WPT department oriented so and so, 29 to 12 and 14, reservation should not be exceeded 22% in the cadre. Accordingly, providing reservation in a cadre, he will exceed the prescribed limit of 22%. That is the extent, but they have not mentioned about the roster. Whether roster is maintained or not, that's not mentioned.
Which department?
WPT is.
WPT. Yeah, WPT.
Now,
Now it is by law social justice,
We file an IL lawsuit, already amended the custody lawsuit, and copy also served to them also.
He is also social justice. His name has been shown in the cause list.
They provided a copy of the.
It has been informed that Mr.
RM Das.
R.M. Das is the standing counsel of
Social justice and.
Social Justice and Empowerment, Social Justice and Women Empowerment,
Social justice
and Empowerment Department of the Government of Assam. Who is the respondent number?
Number 6.
6 to the instant writ petition. Full stop. The said counsel is however not represented. The reason being that his name has not been reflected in the cause list. List this matter again on 16th of February 2026. In the meantime, the registry shall indicate the name of Mr. R.M. Das, SC, Social Justice and Empowerment Department in the cause list. The matter has come up for the second time before me. Earlier also this matter came. I wanted to dispose it of today, but none has appeared. He is actually WPT now. He has left all these things. Yes, what is this? Yes,
This is
Chakravarti.
regarding also non-payment of unutilized leave salary of 300 days. Let's say as per the last order, we have received some instruction from the authorities. As per the last order, we are required to file the affidavit. Let's say the affidavit is ready, only the swearing part is not done. So affidavit is ready, the swearing part is not done. So let's say I may pray for 2 weeks time from this court. Let's say our stand is that let's say
Petitioner retired.
the amount has been paid.
Huh?
The amount has been paid. The prayer has been made as per our this thing, as per our instruction. So we are required to file the affidavit based on this instruction.
So you have received the amount.
Actually, I'm unable to collect the instruction from the cloud. Because this is also the journey in the form of bill, so whether it's paid or not, so I cannot collect this.
You have no telephonic connection with him, with the petitioner? So let them file an affidavit, a short affidavit, and I'll close it on the basis thereof. Mr. CKS Bulwa, appearing on behalf of the respondent, submits that in the meantime, the petitioner have already been paid his dues, his or her, his dues pertaining to leave encashment. And as such, no cause of action further survives. It is the opinion of this court that the same said aspect be brought on record by way of an affidavit. Accordingly, list this matter on 11th of February 2026. Affidavit be filed by 9th of February 2026.
Mas solicitors.
In the meantime, Ms. So-and-so who appears on behalf of the petitioner shall also obtain instruction as to whether the petitioner have received his dues. Yes, what is this?
Case of the petitioner is still covered. But it's on a very narrow metric that on account of pendency of criminal proceedings, departmental proceedings lordship was exonerated.
Let senior counsel for the petitioner submits that a part charge sheet has been filed against the petitioner as well as so-and-so who has in the meantime been promoted. Has filed the instance seeking a direction in this case. Taken out of the seal cover and thereafter appropriate months. You are in seal cover? Okay, affidavit in opposition filed. Okay, now what remains?
The ground which they have taken on account of pendency lordship departmental proceedings, they were exonerated. Departmental proceedings have been dropped. So cause notice was issued that your lordship will find a page 31, departmental proceedings have been dropped. Now, by seal cover, they have kept it on account of pendency of the criminal proceedings. Criminal proceedings was 2017 pending. Till now, lordship, it hasn't reached the stage of framing of charge sheet. The copies of the charge sheet have also not been.
Departmental proceedings initiated when? Dropped. Then what is there?
Yeah. But pendency of criminal proceedings. Departmental.
Then?
Now, lordship, the criminal proceeding.
Now there is one judgment somewhere. If the departmental proceedings are dropped, can there be any criminal proceedings?
Lordship there.
If it is exonerated, is a different thing. Huh?
Been exonerated. They found that there is.
Exonerated.
There is a duty on our part.
Then why-
31. The same set of facts, co-accused in the same case. For him also, the departmental proceedings were dropped. That to that person, they have accorded promotion. Same criminal case is pending. Page 31 is the decision on the departmental proceedings.
Shall not. Yes, madam, what do you have to say?
Lordship, because of this criminal proceeding,
Is the criminal proceedings going on against the other assistant engineer or executive engineer?
Lordship, as per his statement,
His statement, yes, that is his first allegation out there in the first order passed by this court. That there is an assistant engineer, another assistant engineer, he has been given promotion. But you have kept his case under under the seal cover. Isn't that the first order passed by Justice Pumitra Soikia? He says, learned senior counsel for the petitioner submits that the part charge sheet has been filed against the petitioner as well as one Prasanta Kumar Sohoria, who has in the meantime been promoted as the assistant agricultural engineer. According, the petitioner has filed seeking a direction that this case may be taken out of the seal cover and thereafter appropriate orders be passed. What is your instruction on that?
Lordship, as per my instruction, he has been promoted, Lordship.
Who?
The person,
No, whether any department, whether any charge sheet has been submitted against him, Prasanto Kumar Sahoria.
Lordship, my instruction is silent, Lordship, regarding this fact, Lordship. As per my instruction, he has been para, Lordship. In my affidavit, Lordship.
Hello, when can you get the instructions? 2023 matter, how long?
Lordship,
How long are you going to torture him?
Lordship,
It is like a departmental proceedings by you itself. After
Lordship,
exonerating, also giving him slow poison.
Lordship, in the para 17 of my affidavit in opposition, Lordship, as per selection board in its meeting dated 21/10/2021, advised to keep the department in respect of Prasanto Kumar Saharia under seal cover till closure of the
So
department.
why these two yardsticks? That is why I'm here.
Lordship,
Why the two yardsticks? Whether Prasanto Kumar Sahoria
Lordship,
is in the same footing like the petitioner.
Lordship,
For one, you have opened it.
Lordship,
Why?
Lordship,
And not against the petitioner.
Lordship,
That's
that
it.
instruction.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Ms. G. Vora, the learned standing counsel of the Agriculture Department. The grievance of the petitioner herein is that the petitioner case have been kept under seal cover and accordingly not granted the benefit of promotion. Though the departmental proceedings have been, in the departmental proceedings, the petitioner have been exonerated. The counsel appearing on behalf of the petitioner submits that the petitioner's case have been kept on seal cover on the basis that of an OM of the Personnel Department dated 9/5/2006, which stipulates on the basis of office memorandum dated 9/5/2006. The learned counsel, however, submits that there is no uniformity in the yardstick employed by the Agriculture Department of the Government of Assam, taking into account that in the case of the petitioner, his promotion is held up on account of the silk cover. Whereas one Prasanto Kumar Sahoria, the department that have taken a decision to open the seal cover and grant him the promotion. Ms. G. Vora, though apprised this court about the affidavit filed by the respondent Agriculture Department, and more particularly the paragraph number 17, but a reading of the said paragraph do not spell out the reason as to why a differential treatment has been accorded to Sri Prasanto Kumar Sahoria to that of the petitioner. List this matter again on 12th of February 2026, on which date Ms. G. Vora shall apprise this court. An additional affidavit be filed by the Agriculture Department on or before 10th of February 2026, further clarifying their stand taken at paragraph number 17 of the affidavit in opposition. Right?
Hearing challenge has been linked to the inquiry report. And
Huh?
the resultant penalty that has been inflicted on me.
Increment, two increments with cumulative effect imposed upon the petitioner, Basbury, then subsequently upheld when able to challenge. He had the issue notice so and so. So, no affidavit file. You want to file reply?
Yes, Lordship. I.
How much time?
2 weeks, sir.
4 weeks?
No,
8
1
weeks? 1 week? Okay, they filed in the affidavit in the May 2024. You could not file for 2 years. Let me give you 8 weeks.
No, Lordship.
So, Mr. So-and-so appearing on behalf of the petitioner seeks for time to file and reply affidavit to the affidavit in opposition. It is seen that the petitioner has sought for earlier time on 28/4/2025 to file a reply. But however, no reply has been filed. It appears therefore that the petitioner does not have urgency in the matter. Considering the above, list this matter on 8th of June 2026. In the meantime, a final liberty is given to the petitioner to file the affidavit on or before 3rd of June 2026.
Pay for on March, even.
Okay, we have it in July, 13th July.
No,
Absolutely. 1 year you have not filed affidavit. Don't come up with this then. P.K. Roy Chaudhary, what is this?
The previous complete the case of the petitioner is that he was appointed as a constitutional.
Bring better to
Yeah,
establish
sir.
petitioner's domicile in Malaysia was appointed against the post which was based on regional quota of the state of Assam.
He said that,
The
because
order
in fact I
of
was
termination
appointed.
from service.
State
dated
of Assam does not issue domicile certificate. On the basis of Aadhaar card and everything, my lord, affidavit was filed, swearing in before the magistrate, and they have admitted there is no domicile certificate issued by the state of Assam. My Aadhaar card, my election card, my other PAN card, everything result address is in Sribhumi. My lord, I was posted in Delhi, New Delhi International Airport. When they went for a physical verification and found I was not there, so I was terminated.
What?
I was terminated from.
Lordship, actually, the recruitment, in the recruitment.
Why did you go to Delhi?
I was posted there. See, it's
In the recruitment order, Lordship, for 2 years, he was kept under probation. During that 2 years period, Lordship, one physical listing was been verification has been done. And it is one of the condition of the recruitment, Lordship, that is at page number 98 of the affidavit, Lordship.
Okay. Affidavit reply filed.
Everything fine.
Okay, when do you want it? We finished it for disposal when? Even better. So you can do all the whole thing. 2025, early matter, not old.
Terminated, no
Oh,
further.
No termination. Okay. Hello.
Can it be on third, my lord?
How many matters are there? Third? Huh? 3rd February? Matter nahi. Why nahi diyegi? I got a pick for. Chalo. Mr. P.K. Roy Chaudhary, the Learning Council expresses urgency in the matter, taking into account that the petitioner has been terminated from service on 4/10/2024 and has no source of livelihood. First off, considering the above, this matter on 3rd of February 2026 at 2 p.m. for final disposal. Yes, let me rise. Yes, Mr. Dasgupta. What is it?
As item number 28.
What is that?
Matter pertains to pension.
Pension.
Any date, subject to lawful.
Pension is what pension?
Is the bank template. Bank has a pension scheme. Initially, he has not opted for the pension. Subsequently, he has opted for the pension and he had deposited the due amount. Pension was also granted to him. Subsequently,
Whether similar orders have been passed? Similar orders have been passed? No, no.
no order.
Okay, get a date out there.
Any detail of the country?
He's not getting any pension.
No.
Hmm?
Lordship, PF has been taken. PF is his money. Provident fund is 11 lakhs.
Huh?
PF has already been paid.
When?
That is in 2022.
Then what are you going to do with 11 lakhs
Not a
after
pension of
that?
Your
Huh?
Honor. Not a pension of.
Okay. Then also he should, pensioner, we need to finish off. 7th February, 2 p.m.
Item 23.
All dates he will give you.
Under
In time order will be extended, just inform.